Please rise. Municipal Court for the City of Stoughton is now in session. The Honorable Matthew T. Roby presiding.
Please be seated. Please remove all hats, silence all cell phones, and cease conversations. We'll call the court to order at this time. My name is Matt Rothy. I'm the municipal judge for the City of Stoughton, or actually, excuse me, Stoughton Municipal Court. That covers the town of Dunkirk, Rutland, and Pleasant Springs, along with the City of Stoughton. I'd like to go through some of the procedures we follow in the courtrooms. Procedures should be available to you in the pamphlet at the end of the courtroom. We take people on a first-come, first-served basis. When your case is called, please come forward. I'll ask you to enter a plea tonight. Your three plea options are guilty, no contest, or not guilty. If you enter a no contest or guilty plea, I'll review the police report to confirm a factual basis, accept your plea, and find you guilty. And I'll impose an appropriate forfeiture. A plea of no contest is similar to a guilty plea, but a plea arising a conviction arising from a no contest plea cannot be used against you in a subsequent civil case. Let me explain that. Say if you're involved in a traffic accident, you receive a citation. If you enter a no contest plea, you're not admitting guilt, essentially, and they at the next hearing they can't use that no contest plea against you for admission of guilt. The forfeiture range in these citations range from $20 to $1,000. However, almost all are within the $50 to $200 range. The state mandates we add cost to your forfeiture. For example, a $50 forfeiture will result in a total fine to you of $124. I'll grant you 30 days to pay the fine. If you need additional time, please let me know. I'd rather set up a payment plan because I have limited options to collect. I can suspend your driver's license for a year, send your cases to state collections. I'd rather not do that. If you need additional time to pay, just let me or my clerk know. If you enter a not guilty plea, I'll order you to attend a pretrial conference with the city attorney at the next court session, which will be on December 4th, 2019. It's a pretrial conference with the city attorney to see if you can resolve your case short of a trial. Those of you who are facing traffic offenses should understand that you lose demerit points upon conviction of most such offenses. If you lose 12 or more demerit points within any 1 year period, you lose your license to drive in Wisconsin. You'll also be fined. I'd like you to be aware of some of your rights before entering your plea. You have a right to ask for a continuance. This means that you can request that your case be set over to, at another time, either to consult with a lawyer or for some other reason. This is a municipal court. It's civil court. You're not entitled to a public defender, but you may hire an attorney at your own cost. You also have a right to a trial. Please remember your rights when considering your plea. Those of you charged with operating a motor vehicle while under the influence are entitled to request a jury trial in the circuit court upon payment of the proper fees. All their cases will be handled in this court with the right to appeal my ruling to the circuit court. At this point, that concludes my opening remarks. The first case I have is Samantha Milkey. Okay. Miss Milkey, do I have your correct address on Bellevue Road in Stoughton?
Yes.
All right. You've been cited for failure to obey a traffic sign or signal. This citation carries a penalty of $98.80 and 3 demerit points issued your driver's license. Do you have a probationary license?
Yes.
Okay.
No. No.
How old are you?
17.
Yeah, you have a probationary license from the time you're 16 for 2 years past your next birthday, usually until you're 19. The reason why I bring that up is, and I know it's is this your mom? Your mom's standing with you, so I kind of guess it's you. You're treated as an adult for traffic citations, but you have a probationary license. On your second citation, the point total's double. So if this is your first, it stays the same, but your second moving citation, points double for that. I just want to make sure that you're aware of that. So the ordinance in which you're cited cites statute 34604, and the penalty range on this is you're at $30 plus cost now. I can fine you between $20 and $40. So you're at $30 plus cost. You're right in the middle of a narrow range. You understand that? All right. Is that a yes?
Yes.
Okay. I wasn't sure if I could hear you. Do you understand the elements of do you understand what failure to obey a traffic sign or signal is?
Yes.
All right. Do you need me to review the ordinance with you? No. All right. That's 3 points, 98.80. Giving the fine. Any questions for me?
No.
All right. Now's the time I take your plea. Your three plea options are guilty, no contest, or not guilty.
No contest.
You understand with a no contest plea, I must find you guilty?
Yes.
Is this your first citation?
Yes.
Okay, so the point totals will not double, but they will. Once you're found guilty of this, the point totals will double here on out. You understand that as well? And you still wish to enter a no contest plea?
Yes.
All right. Let me read the police report. I want to make sure I have a factual basis for your plea. Okay, I have read the police report. I do find a factual basis for your plea. I'll accept your no contest plea and find you guilty. Anything you'd like to say before I decide on a sentence?
No, sir.
Okay. I do find the forfeiture to be appropriate. I'll impose a penalty of $98.80. How much time do you need to pay?
I can pay today.
Okay, I'll give you 30 days, and you can just take the notice downstairs at the dispatch window and make payment then. I presume you came here tonight because you wanted to find out what about the traffic, because it was not a mandatory appearance.
Yeah.
Okay, you just want to find out about the court procedures and what happens, and so
And
forth.
see if I could get any points back.
Okay. I can't for the points, and you're at 3 points is the minimum for a moving violation. If you ever get in, you can always do what's called a point reduction class. Would you like some information on that?
Sure.
Okay. If you complete that class, usually they give you 3 points back as well. So, any questions for me?
I know.
Once you receive the notice from the bailiff, that will take care of it for this evening then. Thank you.
Thank you, sir.
The video's down. Is there going to be video for the trial?
Yeah, we have it all set. Okay. And both are winning.
Okay, wonderful. Jessica Reichman? Evening, Ms. Reichman.
Hi.
Do I have your correct address on East Road 7 in Edgerton? All right. You received a citation for operator violating a red traffic light. This citation carries a penalty of $98.80 and 3 demerit points issued your driver's license. Forfeiture range on this is as follows. You're at $30 plus cost. It's likely to be a narrow range for this. 1C. Yep, $20 to $40, so you're right in the middle of a narrow range. And you understand what operator violated a red traffic light is?
I do.
Okay. Now, this is a mandatory appearance, and the reason why I said it's a mandatory appearance for that is that if you're found guilty of this, the Department of Transportation mandates that you take a class, a traffic safety class.
Oh,
So that's why I want to make sure that, and it's nothing that this court has any control over, but that's something that the DOT mandates that we say, and I thought I'd rather inform people and have people come in for a mandatory.
it's good to know.
Yeah. So, if you're found guilty for that, so you're aware of the class now? And in order, she's nodding her head, so I'll say yes.
Yes.
So, and in order, when the DOT sends you the class, you have to take it in order to maintain your driver's license.
Okay,
All right. You understand what operate violate traffic light is?
I do.
Okay. Any questions for me regarding this citation?
No.
All right. I mean, and let me just, as a final, if I can't change the citation or the points, but if you would like to change the citation, you can always enter not guilty plea and talk to the prosecutor as well.
Okay.
All right. With that, you ready for a plea?
Yes.
And the plea would be?
No contest.
You understand with no contest plea, I must find you guilty?
Yes.
And you understand that you have to take the class as well?
Yes.
Let me read the police report. I want to make sure I have a factual basis for your plea. Okay, I've reviewed the police report. I do find a factual basis for your plea, accept a no contest plea, and find you guilty. Anything you'd like to say before I decide on the sentence?
No.
Okay. I do find the forfeiture of 98.80 to be appropriate. You're already at the minimum of 3 points, so, how much time do you need to pay?
The 30 days would be great.
Okay, I will give you 30 days. Make sure that you pay, because if you don't, the only
I'm
option.
sure it gets worse, right?
Yeah, well, the only option I can do is to either send your amount to collections or suspend your driver's license for a year, and I'd rather not do that. If whatever happens, if you need more time to pay, there's a number on here that you can call and request a hearing, and I don't have any problem
And
extending.
I just pay at the dispatch window when I'm ready?
Exactly.
Okay.
Or you can mail in payment on there
All
as well. Okay, thank you.
Thank you. Thank you. Am I free to go now?
Okay, good. Lucas Husman? Is it Husman or Husman?
Huseman?
Husman.
Yep.
Wow, thank you for correcting me. I drive your correct address on Fairfield Street in Stoughton.
Yeah, 2450 Fairview.
All right. Okay. You were, Mr. Husman, you were cited for operating a motor vehicle while under the influence of an intoxicant. That citation carries a penalty of $861 and 6 demerit points issued to your driver's license. Do you understand what operating a motor vehicle while under the influence is?
Yes.
All right. Now, the penalties, in addition to the 861 and 6 points, are as follows. It is a 6 to 9 month driver's license revocation if you're found guilty. You are required to attend an alcohol and drug assessment class. If your blood alcohol content was a 1.5 or higher, or if there was a refusal, what happens is I must order an interlock ignition device be installed and all vehicles registered in your name for a period of 12 months. Now, there's two components to the IID, interlock ignition device. Basically, it's, you know what an IID is?
A little bit. I've talked to some people about
Right.
it, yeah.
It's a machine, it's a tube that you have to blow into in order to start the vehicle.
Right.
And if the IID is, that's the nickname for it, if it registers shows any alcohol on your breath, what will happen is your
Won't
car won't be
start.
able to start, correct.
Okay.
Correct, so, and then if that's the case now, so there's two components, you have to have it on all vehicles registered in your name for a period of 12 months, and you also, if you're driving any car, it has to be equipped with an IID then.
Okay.
So if you're driving at work, you have driving a work vehicle, the work vehicle would have to have an IID as well. And there's a $50 surcharge to the IID. Now, I don't see, usually there's a companion ticket, what's called a prohibited alcohol concentration, and I don't see that. So either one has been ordered, or, oh, okay, so there was a refusal, so you requested a hearing for the refusal hearing within the 10 days.
Okay.
Okay, so what that means is that you have 10 days to request a refusal hearing, and you did so. Otherwise, could be revoked for 12 months.
Right.
So, okay.
Good thing we did that, right?
What's that?
Good thing we did
Yes.
that.
Yeah, that is correct. And you are unrepresented at this point, is that correct?
Yes, sir.
Okay, since you requested a refusal hearing, those are the penalties. And if you're found guilty, you've talked about the revocation and the driver's license. The 6 to 9 months, it's 12 months if it's a refusal. The refusal automatically carries 12 months. The other citation also carries a 6 to 9 month revocation period, and I usually base that upon your blood alcohol content in the driving. Basically, if you're under a 1.5, it's 6 months. If you're 1.5 to 1.9, it's 7. If you're above a 0.2, it's 8 months. And if there's bad driving, I add a month. But since you've already requested a refusal hearing, what I would suggest is that we enter a not guilty plea for you, because I can't have a hearing without the prosecutor tonight, and we usually set that over. I would suggest you enter a not guilty plea. Schedule this matter for a pretrial conference with the city attorney on December 4th, and see if we're able to reach a resolution prior to trial.
Okay.
Does that sound something that you would want to do?
Yeah, since I did that refusal thing, it's for sure a 12-month
No,
license
and that's
suspension?
something that and it's revocation versus suspension. Revocation's a little more serious than a suspension then. So, but that's something it's not, since you filed the timely appeal, there is no revocation at this point until you're convicted then. Otherwise, it would have been a 12-month driver's license revocation at the end of 10 days.
If I didn't
If
do
you
the
didn't
letter.
file, but you filed, so there's.
Yeah, I was talking to her about it, and we were like kind of phone tagging and stuff, but
Okay, so
we got it done though.
that's
so.
what we'll do. We'll enter a not guilty plea. we'll schedule the matter for a pretrial conference, and we'll prepare the form to you, and I'll give you that notice. We have some rules with the pretrial conference. I order that you appear. If you don't appear, I'll find you in default, and I'll find you guilty, and I'll impose those penalties, including a 12-month driver's license revocation. Okay? Bring whatever witnesses or documents might help your case, because it's a chance to tell your side of the story with the prosecutor. And finally, we hold the pretrial conferences downstairs on the first floor. When you enter the building, there will be, you'll go through you'll go through 2 sets of doors, and there will be a conference room on your left marked pretrial conferences.
Okay.
I always advise people to go take a look at the room before they leave, and it's downstairs in this building then.
Okay.
Okay, any questions for me?
And what time is that court date? Does it show?
4:45.
Okay, good. So I don't have to miss any work.
Okay, any other questions for me?
No, sir.
That will, since you got the pretrial conference notice, that will take care of it for this evening then.
Okay, thank you
All
very
right,
much.
thank you. Ava Loftus? Ms. Loftus, do I have your correct address on Milwaukee Street here in Stoughton?
Yep.
All right. You were cited for failure to yield at an uncontrolled intersection. That citation carries a penalty of $98.80 and 4 demerit points issued to your driver's license. Do you understand what failure to yield at an uncontrolled intersection is?
Yes, sir.
All right. Now, for the citation, the total forfeiture is $98.80. It's $30 plus cost. Now, the forfeiture range is as follows on this. And while I'm looking that up, you approached with 2 people. I presume that these are your parents?
Yeah.
Okay, thanks. The forfeiture range is $20 to $50 plus cost. You're at $30 plus cost. You're kind of in the middle of a narrow range. You understand that as well?
Yeah.
All right. Now, since you brought up your parents, do you have a probationary license?
Yes, I do.
Okay. Is this your first citation?
Yes.
All right. So the first citation, the points stay the same. But upon your second or subsequent, second, third, fourth, et cetera, your point totals will double while you have a probationary license. You understand that?
Yes.
All right. So, given that, and as you've been sitting in court, I can't really negotiate the points or anything like that. So I can maybe reduce the forfeiture only to $20 plus cost, but that's it. So, do you understand that as well?
Yes.
So basically what I'm alluding to is if you're just here to explain what happened, I can hear that, but if you're here and you want to contest the points, what I would suggest is you enter not guilty pleas as well. You understand that as well?
Yep.
Okay. Any questions for me?
No, sir.
All right. Now is the time I take your plea. Your 3 plea options are guilty, no contest, or not guilty.
No contest.
Do you understand with no contest plea, I'll review the police report, and if there's a factual basis, I'll find you guilty?
Yes.
All right. Let me read the police report. I want to make sure I have a factual basis for you. Too. Okay. I have reviewed the police report. I do find a factual basis, accept your no contest plea, and find you guilty. Anything you'd like to say before I decide on a sentence?
No, sir.
Okay. I do find the forfeiture of $98.80 to be appropriate. I'll impose that penalty. How much time do you need to pay?
Just the 30 days.
Okay. I'll give you the 30 days, and I'll give you the notice, and you can either stop in and pay at the dispatch window, or you can make payments. It will be assessed at 4 points. In reviewing the police report, it just seems that you thought that you could make it across the intersection, and it didn't. It just seemed like it was just kind of, you're a relatively new driver, is that right?
Yes.
Probably just something that you probably didn't have the correct estimation, is that right?
Yes, sir.
Okay, and you'll learn from that and make sure that to be more careful then?
Yes.
Okay, that's all I have. Anything else for me?
No, sir.
Or once you receive these, the notices, I will take care of it for this evening then.
Thank you.
Thank you. Isaiah Ruffins? Mr. Ruffins, you've been here before,
Yes, sir.
but you're not a trumpet player. You're a musician, but not trumpet, correct? Oh, I remembered that, so. Do I have your correct address on Brooklyn Street, Stoughton? Is that yes?
Yes, sir.
So we're recording this, so when I ask questions, if I make a mistake, you have a right to appeal my ruling to a circuit court judge, but that's only based upon a proper record. So if you nod your head, the record doesn't pick that up. So the record will be incomplete. So if I make a mistake, you won't be able to appeal me then. So it's always important to make sure that you answer my questions then. So
All right.
kind of for your sake too, to make sure that I'm doing the right thing as well. All right. You received, let's see, a few citations. The first one is for failure to yield the right-of-way from a stop sign. Now, that citation carries a penalty of $98.80 and 4 demerit points issued your driver's license. Now, do you understand what failure to yield the right-of-way from a stop sign is? Is that yes?
Yes, sir.
Okay. The camera doesn't pick up
Okay.
either, so yeah, that's okay. Now, so you understand the elements. Now, this is a forfeiture of $98.80. Now, that's $30 plus costs. Now, the forfeiture range on this is $20 to $50. So you're $30 plus costs. You're kind of in the middle of a narrow range as well. You
Yes, sir.
understand that?
Yes, sir.
Okay. Now, this is a mandatory appearance. The reason why I make it a mandatory appearance, and this is, you've seen most of the people, you've been in court for a little bit. Most failure to yield citations, the Department of Transportation requires that you take a class in order to obtain your license. It's something out of my control, out of this court's control. So if you're found guilty of this, what will happen is you'll get a note from the Department of Transportation saying you got to take a traffic safety class in order to keep your driver's license. You understand that? Okay. Now, any questions regarding this citation?
No, sir.
All right. Next question is operating motor vehicle without insurance. This citation carries a penalty of $124. Do you understand what, and 0 points. Do you understand what operating motor vehicle without insurance is?
Yes, sir.
All right. Forfeiture range on this is $50 plus costs. Is $0 to $500. So it could be 0, but it could be as high as $500 plus costs. You're not quite at the minimum, but you're on the lower end of the scale. You understand that as well?
Yes, sir.
All right. Now, the last citation I have tonight is operating after suspension. Now, this citation carries a penalty of $124 and 3 demerit points issued your driver's license. Do you understand what operating after suspension is?
No, sir.
Is that yes?
No, sir.
Oh, you don't? Okay. Do you want me to read the citation to you?
No, sir.
Okay. Okay. So I want to make sure that people have an understanding of what these citations are. So operating after suspension basically means that your license was suspended and allegedly, and that you were operating a motor vehicle while your license was suspended. Does that clarify your understanding?
Yes, sir.
Okay. And the penalty range on this is $50 to $200. So you're actually at the minimum plus cost.
All right.
All right. Any questions regarding this citation?
No, sir.
Okay. Those are the 3 citations as I've before me today. Now, I can't reduce the points on any of them. I can't dismiss any of them. But if you would like to talk to the prosecutor and maybe, discuss all 3 citations, what I would suggest is enter not guilty plea. Talk to the prosecutor. But that is your option. You're shaking your head, but I want to make sure that you
You already know what I'm finna say. I'm guilty. I don't care. I'm trying to get out of
Okay,
here.
well, any other questions for me?
No, sir.
All right. I'm sorry?
I do.
Yes.
I'm his parent, so I haven't. The reason I'm asking is because he did get a letter from the people, because there was an accident involved. I'm wondering if he's better to plead a no contest with it, even though he gets the citation, so we can deal with this part of the accident, because they were going faster than what they should have.
Right.
And it would have caused the accident if they weren't going over the speed limit in the first place. Because he
Right.
did stop sign.
Right. Well, I don't want to hear too many facts because the prosecutor's not here, so I can't have any knowledge of any, if this were to enter not guilty plea, I can't have any knowledge before the trial is. But if you've got a letter and you've got some proof, that might be a case where you can meet with the prosecutor and see if you can negotiate
Okay.
a better deal than what we have here tonight.
But I'd rather just go with, just go with guilty then, I guess.
Is that, well,
Guilty.
you had enough time to consider your pleas?
Guilty. You already know.
Okay,
I was
you want to
gonna say
enter
that.
guilty to all three? Okay.
Guilty.
You understand that with a guilty plea, I must find you guilty in all three?
Mhm.
Is that a yes?
Yes, sir.
All right. Let me review the police report. I want to make sure I have a factual basis for your plea.
All right. That's why I said guilty, so I can just go home.
Okay, I have read the police report. I do find a factual basis for your plea. I'll accept your guilty plea and find you guilty. Anything you'd like to say before I decide on a sentence?
No, sir.
Okay. Did I hear you just want to go home?
Yes, sir.
Well, but make sure that I want to make sure that you're aware of your rights and that your rights are protected as well. So, okay, for these, your driver's license is suspended. Do you have a driver's license?
No, sir.
Are you attempting to get one at all?
Yes,
Okay,
sir.
so you'll have to take a traffic safety class on top of that, but that might actually help. And then these points will be assessed. Since have you ever had a driver's license?
No, sir.
How many traffic because the second or subsequent citations will be assessed double the points. So this one is a 4-point. Have you received any additional citations?
No, sir.
Okay, so the 4 one will be good, and the other 2 had 0. So
Right.
or actually one had 3.
Mhm.
So the operating after suspension, that's a non-moving violation. So I should have clarified that. Moving violations will double. So the 4 will stay the same and the 3 will stay the same, but you're kind of down to 5 points already before you get your license in. So just be careful. And what I'll say for this, you're already at the minimum forfeiture from operating after suspension. So you're at 124. I'll keep that at 124. Operating motor vehicle without insurance, I'll keep that at 124. But what I can do for the failure to yield the right-of-way, I'll drop that to the minimum forfeiture of $20 plus costs. Doesn't save you much, but it saves you $86.20, so it saves you $12.60.
All right.
So, don't go that. How much, do you need time to pay?
Yeah, 90 days.
Okay, I'll grant 90 days to pay for all 3 of those, and if you need, what's that?
Let's do
30.
it in 90 days.
No, 30.
You want to do 30?
Mm-hmm.
Okay,
Getting this shit over with. You know I don't like court.
okay,
30.
okay. So, I'll give 30 days, but if you need additional time, you know what? Why don't we say 60? And that way, it's kind of a good compromise between us. If you need additional time than that, there's a number you can call, and then either appear in court or see if you have more time.
All right.
Did I just, did I miss you? So, we changed the form. I know, you're trying to get out of here faster, and because of the form, we'll change the forms, but you did okay. So, all right, I'll grant 60 days,
Okay.
and if you need no time, just call the number on and ask for more time.
All
I'm
right.
happy to grant it to you as well. All right, what'd you learn?
They can drive no more without having a license.
Nah, I'm still whipping.
Okay, you're still what?
I said I'm still whipping.
Okay, okay. Just be careful on these uncontrolled intersections
I
and
know.
so forth, so. All right, since we got a minute, well, tell me about, I asked you last time if you played the trumpet, you said no, but you're a musician, right? How's the musician work going?
I rap and I engineer. I've been having more clients trying to come in and stuff like that, so.
Is it going well so far for you?
Yes, sir.
Okay, so, at least if I see you, then you can tell me about how the music career is going. And I'd be
Yes, sir.
interested in that, so. Okay, thank you for coming in. Once you, the bailiff will review that with you, and once you're done with that, that will take care of it this evening. Garth Ewing?
Your Honor.
Good morning, good evening. I said the
Evening,
same thing to the
morning.
judge this morning,
Yeah.
so my apologies. Mr. Ewing, do you have, you've been cited for failure to yield while making a left-hand turn. Do you have a proper address on, do I have your proper address on Van Buren Street in Stoughton?
745, yeah.
Okay, that's
Yeah.
what I have. Do you understand what failure to yield while making a left-hand turn is?
I do.
Okay. Penalty on this is $98.80, and 4 demerit points issued your driver's license.
Okay.
Forfeiture range on this is $20 to $50. You're at the minimum. You're in the middle of a kind of a narrow range. You
Sure.
understand that as well? Okay. Now, this is a mandatory appearance. The reason why it's a mandatory appearance is that if you are found guilty, the state will send you the DOT will send you a mandatory class that you have to complete the class in order to obtain a driver's license. I want to make sure people are aware of that. You're aware of that as well?
I am aware of that.
Okay.
Thank you.
Any questions for me regarding this citation?
The citation, so failure to yield. So if
If
the
you have
other-
any questions regarding the citation about I can read you the ordinance, I can't give legal advice or hear facts. If you have
Yeah.
any doubt about this, you should enter a not guilty plea and talk with the prosecutor about it. Prosecutor, we said,
You know, it's just, there's so much, like, they have a witness, but there's no way there could be a witness because there was no one there.
okay, so why don't we enter a not
And so
guilty?
it's just kind of,
Why don't we enter a
um,
not guilty plea and we'll schedule this for a pretrial conference?
yeah, that'd be good.
Okay.
Yeah. I want to just be like no contest and get it over with.
But I think that it's
really
important that you
have-
maintain your rights and so.
Yeah.
So the pretrial conference, I'll give you the form in just a minute.
Okay.
I'll order that you appear, and it's a chance that you meet with the city prosecutor. Meet with the city prosecutor see if you can resolve it short of the trial.
Okay.
You can bring up any type of witnesses or anything like that.
Okay.
So bring whether witnesses or documents might help your case. Make sure that you appear, because if you don't appear, I'll find you in default, find you guilty. So make sure that you appear. And I always advise people to go take a look at the room before they leave. It's on the first floor. It'd be December 4th.
Okay.
Through the second set of doors in a conference room on your left.
Okay.
All right, once you receive that form, that will take care of it this evening.
Thank you, Your Honor. Okay. Thank you, sir.
You approved reopening it last week.
Okay.
She was sent to corrections, and that's what brought this all about. And then she called and said, well, she couldn't go to the initial, so you approved reopening it, and I explained to her then it's automatically scheduled for pretrial, which I did, and now she's here.
Okay. Court will call Kenesha McCullough.
It's
Kenesha, I'm sorry. I think I might need new glasses. No, I apologize. Okay. See, you're in the hospital and you missed your initial, and then we had a motion reopen that was granted, and there's a pretrial conference today at 5.
Okay, sir, this is what I don't get. Why do the black people that come in here got to go through pre-trials and all of that? I mean, why can't I get the same satisfaction that everybody else got? It's the first time I've had a ticket on my license, period.
Okay. The reason why is you recite, normally I have you go for the pretrial conference. Do you have insurance on the car?
No, I don't. I can't afford it.
Okay. Well, that's something that if you could talk to I can't control the prosecutor, what they do. They're the ones that
But
enforce.
why is it that we always got to wind up seeing prosecutors and stuff like that for these kind of situations? You got drunk people coming in here with drinking and driving when they shouldn't be. I wasn't drunk or any of that.
Uh-huh.
You know, it's just a ticket for insurance. Can't I get a chance to pay the ticket?
You want to pay the ticket?
Yeah, I want to pay it, but I can't pay it all at once.
How much
I
time-
have half of the money today to pay it.
Okay.
I think it was $150. I got $50 to pay on it right now.
124.
Oh, okay. Well, I didn't know. Gosh, this don't make no sense. They mess with our livelihoods too much in this world.
Do you just need time to pay?
That's it.
Okay. How much time do you need to pay? You said, how much could you, $124. How much
You
time?
give me 2 months.
Yeah, sure. 60. I'll give you 60 days to pay from today.
Matter of fact, I'll pay it. If I could try to pay it all on the 26th, I'll pay it all.
Okay. I'll give you 60 days. Is that sufficient?
Yes, sir.
Okay. So give you 60 days,
Yes, sir.
and then I'll give you a notice of that. instead of, there's pretrial conference, so the prosecutor will come up and they'll say that you didn't appear, but I'll tell the prosecutor
Is that the lady in the desk in the front when
Yeah.
you first walked in?
Yeah,
I was under the impression, when I talked to the person over the phone,
Uh-huh.
that they were going to get me back in court. They didn't say anything about a pretrial. They didn't say anything about a prosecutor or any of that.
okay. Okay, but you don't want to talk to the prosecutors, that's my understanding. Is that
No,
correct?
I don't, because
Okay.
I don't have a reason to.
Okay, so you just want time to pay.
Just, that's it, and I'll pay the ticket, and I will make sure I'll get insurance some kind of way for their number liability within the next 30 days.
Okay, so what we'll do, the reason why I have the pretrial conference is if you get insurance within the next 30 days, the citation will likely be dismissed. I can't dismiss it, but the prosecutor usually can, because they have to have the right in. So that's why, I know it's troublesome and it's time consuming, but if you're able to get insurance in the next 30 days, then what happens is like the citation will
The
likely
thing
be
is
dismissed.
finding affordable insurance.
I understand.
That's the thing, finding affordable insurance, and I am kind of like displaced in my home situation right now. If you notice, I have a P.O. box for an address.
Yes, okay. Okay.
So I'm kind of like, I'm working part-time barely.
Well, how about this? Why don't we do it this way? Instead of paying in 60 days, I'll note to the prosecutor that you appeared tonight, and if you provide the court with proof of insurance in the next 60 days, the citation will be dismissed.
Okay, that'll be fine.
Okay.
That'll
So
be fine.
We'll send a notice to that post office box, so we'll give you, how about, what's 60? January 19th. Send in proof of the insurance by that date, and then if you provide proof, then the citation will be dismissed.
Okay, thank you so much.
Okay,
I
I'll
appreciate
I'll
that.
tell the prosecutor that as
Do
well.
I
'cause
need to
that's-
sign anything?
Nope, I'll make a record of it with the court.
Are you sure? Because like this kind of stuff, if you don't have anything to prove what, you know.
What I can
I
do-
believe you, but.
Right, here's what we can do. We'll send you a letter in the mail, and that way you confirm what I said today.
Okay, so do I lose points or something on my license?
No,
or-
you haven't been found guilty of anything yet. And besides, the operating motor vehicle without insurance is a 0-point citation.
Okay, okay. All right, I didn't know, so,
Okay.
all right.
All right, we'll
Thank
send you a letter, and I'll tell the prosecutor that's what happened.
Do you have a card for this place so that I can be able to address?
Why don't you mail it with the letter?
Sorry, if I have to January 19th to get some insurance, I gotta
I'll
find
send you, everything will have the address, I'll
Okay.
send it out this week, so
Okay.
you'll get it in the mail.
All right, thank you so much. So my license is fine.
Yep, I
Okay.
canceled that suspension.
All right, thank you.
Okay, all right. What- Yeah, it has been. Don Warren? It was this week, wasn't it?
Always record.
Thank you for your patience, Mr. Warren. Thank you for your patience.
Yes, thank you, Your Honor.
All right, do I have your correct address in Spring Road in Stoughton?
2008 Spring Road.
You were cited for speeding on a city highway, 11 to 15 over the limit. Do you understand what speeding on a city highway is?
Well,
You don't have to tell me. Do you understand what speeding is?
I know what speeding is. I don't know if it was I was turning on to Page
You
Street.
don't tell me the if I hear too many facts, I have to recuse myself, and you'd have to go in front of another judge then. But I just want to make sure that you understand the citation then. Yeah, I want to make sure that you understand the citation.
Okay.
So, all right, it was 11 to 15 over the limit, and at that level, it's 4 points issued against your driver's license, and a total forfeiture of $98.80. All right, now, you understand that so far?
Yes, I do.
Okay, now, the $98.80 is, that's $30 plus costs, okay?
Okay.
The range on this is 30 to 300, so you're actually at the minimum forfeiture amount.
Okay.
Now, my court's policy is I give a 10-mile-an-hour leeway for speeding citations. In other words, if you were to enter a not guilty plea and see the prosecutor, they would initially make the same offer of basically 3 points, or 1 to 10 over the limit. So what I'm willing to do is I'm reducing this in court from 11 to 19 over the limit to 1 to 10 over. That'd be 3 points instead of 4. You understand that?
Yes, I'd appreciate that.
All right. And toll forfeiture still is $98.80 because that's the minimum.
I understand.
Okay. Any questions for me?
So do I need to appear again?
No. Well, normally, if you have any questions for that, so if it's 1 to 10 over, then the next step would be to take a plea to 1 to 10 over at $98.80. Your 3 plea options of that would be guilty, no contest, or not guilty. And if I could, if you don't know what those pleas are, I could explain them to you, what each of them mean.
Well, I guess all I'd like to do is try to keep the points as low. I'm not opposed to paying the fee, but I have to contest the method by which I was apprehended because of the nature.
Okay, so if that's the case, what will happen then, if you're contesting the nature of it, I will go ahead and enter a not guilty plea on your behalf.
Okay.
Mr. Warren, I have to make the notation on my docket list. Okay, so I will enter a not guilty plea, and we'll schedule this matter for pretrial conference with the city attorney. And at the pretrial conference, you can discuss the city attorney, the method of apprehension. Okay, it's a chance to tell your side of the story, so bring whatever witnesses or documents might help your case.
Okay.
Now, it will be scheduled on December 4th, and I'll give you the notice in just a minute. It'll be held downstairs. On the first floor, as you enter the building, you go through 2 sets of doors. There'll be a conference room on your left marked pretrial conferences. That's where the conference will be held.
I see. Okay.
So, and make sure that you appear, because if you don't appear, I'll find you in default, and I'll find you guilty and impose those penalties.
Okay.
And it will be the 11 to 19 over. It won't be the 1 to 10 over. You understand that?
Yes, I do.
Okay. The bailiff will give you a notice in just a minute. Once you receive that, that will take care of it for this evening then.
Okay. Thank you very much.
Thank you. Preston Roberts?
2 more on the next page.
Yeah, I see that. Good evening, Mr. Roberts.
Good evening.
All right. Do I have your correct address on Lookouts Trail in McFarland?
Yes.
Okay. You received a number of citations. Let's go through them all. One is operating after suspension. This citation carries a penalty of $124 and 3 demerit points issued your license. You understand what operating after suspension is?
Yes, sir.
Okay. Do you have a probationary license?
Yes.
Okay. So on moving violations, your first one stays the same, but on every other moving violation, if that the point total is double, correct? So that is the operating after suspension. Next citation is loitering or prowling. That citation carries a penalty of, hang on a second. Just a minute, sir. Okay. Want to make sure. You marked as juvenile, you're 17, but you're considered an adult at 17, so this is an open, we're being broadcast right now, so I want to make sure that you're protecting your rights, but you're considered an adult for this. So the second citation is for loitering or prowling. That citation carries a penalty of $124. You understand what loitering or prowling is?
Yes.
All right. And that's a 0-point citation. That's not obviously a moving violation. Okay. So those are 2. The next citations I have for you is possession of THC. This citation carries a penalty of $439. However, if you complete an alcohol and drug assessment class, what I do for that, and I can have a list for that, I reduce the forfeiture from $439 to $124. Just want to make sure that you complete the class and know more about THC.
Yes, and
Hang on, you were going to tell me about something else, or, I mean, I can't hear any facts or the circumstances regarding your
I was
citation.
going to ask you a question.
Yeah, go ahead.
When was the citation issued? What was the date?
That citation was issued on October 12th. There was another one in August. You also have another one for operating after suspension, also $124 and 3 demerit points. Hit and run, unattended vehicle, $187 and 6 points. You understand these citations as well?
Yes.
All right. And then failure to keep vehicle under control, $136.60 and 4 demerit points issued to your driver's license. And finally, failure of operator to notify police of accident, that's a $313 citation and 6 points. Now, I cannot do anything regarding the points or dismissing various tickets. What I would suggest is that you enter a not guilty plea, talk to the prosecutor, and see if, who just entered the courtroom then, to see if you're able to resolve some of these citations. You understand that?
Yes, sir.
Is that what you want to do?
Yes.
Okay. Well, go ahead and enter a not guilty plea. Schedule the matter for pretrial conference, and that will be held on December 4th.
Okay.
Are you here on December 4th, Ms. Collins?
Yes, sir.
Okay, you'll be meeting with her. So make sure that you appear, because if you don't appear, I'll find you in default and I'll find you guilty and impose all the forfeitures that I just listed. Okay. Now, I always advise people that it's a chance to tell your side of the story, so bring whatever witnesses or documents might help your case. And then also, I always advise people to take a look at the room before they leave. It's on the first floor of this building. You go through the second set of doors, and as you go through the doors, there will be a conference room on your left marked pretrial conference.
Okay.
So, now, given that, again, I'm ordering that you appear, because make sure that you appear, because if you don't, what will happen is I'll find you default. The reason why a lot of times people just like to resolve their cases short of a trial.
Yeah.
But you still have a right to a trial. You still have a right to ask for continuance as well. So I want to make sure that everybody's rights are preserved as well.
Yes.
Okay. Any questions for me?
No, Your Honor.
All right. I will. It's going to be a couple minutes. What you can do, if you have a seat in the bailiff for now, we'll give you the notice of pretrial conferences when they're completed.
Okay, thank
All
you.
right. Thank you. Okay. There's somebody back there? Okay. Both of them are? Okay.
First trial, he's appearing by phone.
Oh, the guy from Minnesota. Okay. Okay. Make sure that they're with him, and I'm going to adjourn for a few minutes to visit the restroom. I should have raised the pre-trial conference, but she was being too disruptive. That's right. Andrew Strouder? Mr. Strouder, do I have your correct address on Jackson Street in Stoughton?
Yes.
All right. You received 2 citations. The first one was for loitering prowling. That citation carries a penalty of $124. Do you understand what loitering or prowling is?
Yes, sir.
All right. Was that a yes?
Yeah.
Okay, thank you. So the forfeiture range on this is $20 to $1,000. You're at the $50 plus cost range, so I could either lower it or raise it depending on if there's circumstances. You understand that as well?
Yes.
All right. Your second citation is as follows. It's for receiving stolen property. That citation carries a penalty of $313. Do you understand what receiving stolen property is?
Yes.
All right, and that's also, the forfeiture range on that is also $50 to $1,000. You're at $200 plus cost. You understand that as well?
Yes.
All right. In addition, for stolen property, I could order restitution. Do you know what restitution is?
Yes.
All right, and restitution is basically where if somebody's deprived of property or value, I could order that you pay that person the value of the property or value. You understand that as well?
Yes.
All right. Any questions for me?
No, sir.
Now's the time I take your plea. Your three plea options are guilty, no contest, or not guilty. Would you like me to explain each of those plea options to you? Okay. Are you ready to enter a plea?
Well, actually, yeah, please, yeah, can you run it? Yeah.
Sure. A guilty plea means that you're guilty of both citations. You would enter a plea. I would review the police report, verify that there was a factual basis, find you guilty, and impose forfeitures for both citations. And possibly restitution on the one. No contest plea means that you're not necessarily admitting guilt, but you want it to end today, and you don't want to come back, and you're not admitting guilt, but I would find you guilty anyway because of. No contest plea basically means you don't want to admit guilt, but you don't want to take the matter to a trial either. No, that's your second option. Not guilty plea means that you believe that the city couldn't prove your case, or that you're not guilty, or that you want to meet with the prosecutor to discuss these two citations and possibly get a reduction in the penalties. Those are the three plea options. Have I adequately explained the plea options to you?
Yes.
Okay. If you have any doubt about any of this, what you should do is enter a not guilty plea to allow yourself to talk to the prosecutor.
Yeah, I'll do that.
Okay. We'll enter a not guilty plea on your behalf. What I'm going to do, I'll order that you attend a pretrial conference with the prosecutor. That pretrial conference will be settled December 4th. I'll give you the notice in just a minute. You'll be meeting with Ms. Collins, who's seated to your right. And then it's a chance to tell your side of the story, so we'll bring whatever witnesses or documents might help your case. Ordering that you appear, because if you don't appear, I'll find you default, and I'll find you guilty, and I'll impose those penalties. And then I always advise people to go take a look at the pretrial conference before you leave. It's down on the first floor. You walk through a set of doors, and it'll be a conference room on your left to mark pretrial conferences then. Okay, any questions for me?
No.
All right, the notices, my clerk will give them to the bailiff will give them to you, and that will take care of it this evening then. Thank you, Mr. Slaughter. Well, hang on a sec, let me give you the forms first. Okay, court's gonna take a 2-minute recess, I'll be right back. Oh, you got his number? Why don't we wait till she's on? Judge Matt Rothie from Stoughton Municipal Court.
I'm gonna put him on speaker.
We're going to put you on speaker in just a minute.
So if you hold on for 1 minute.
Mr. Almquist, can you hear us?
Yes.
All right. You're appearing by phone. We're going to go ahead and call the case of, court's going to call the case of City of Stoughton versus Carl Elmquist. Please state your appearances.
Attorney Amy Collins O'Hara appears for the city.
And you are Carl Elmquist?
Correct.
And you're appearing via phone, and which I previously granted permission.
Yes. Praise the Lord for high-tech stuff.
All right, thank you. All right, this is for an unlawful U-turn citation. Mr. Elmquist, have you ever been through a trial before?
Well, I'm no seasoned veteran of it, but I've sat in on a few of them, and then some other traffic stuff.
Okay, so let me go through some of the procedures we follow. The City of Stoughton is represented by Attorney Amy Collins. They're the prosecuting, and they have the burden of proof of proving an unlawful U-turn. So what will happen is I will ask for an opening statement from both the city and from you. You do not have to give an opening statement. It's not considered testimony or evidence. It just is a helpful guide to me if you want me to be persuaded. Then the city will then call witnesses. Ms. Collins will conduct what's called a direct examination on the witnesses. I ask them questions, and then after she's done with the witnesses, you'll have the right to cross-examine them. And to basically cross-examine them is ask them any further questions after what Ms. Collins said. Now, under Wisconsin, cross-examine is wide open, so you can ask questions on cross-examination as long as they're relevant. You understand that?
Okay, I think so.
All right. Now, after Ms. Collins has concluded her direct examination and you've done your cross-examinations, you also have the right to call witnesses, including yourself. Do you understand that?
Okay.
And instead of a question-answer format, usually what I tell people is that they can just give testimony in a narrative format.
Okay.
And then after the testimony is concluded, then Ms. Collins may call any rebuttal witnesses. You can then call rebuttal witnesses, and after all the rebuttal witnesses have concluded, if any, then I close the evidence and you have closing remarks. Ms. Collins goes first, you go second, and then since Ms. Collins has the burden of proof by clear, satisfactory, and convincing evidence, she goes last. Do you understand the procedures as I've set forth?
I think so. One thing I did have a question regarding subject matter jurisdiction for the case even to be heard by an honorable court. Can subject matter jurisdiction be proven on the record when there's no eyewitness and there's no fact?
I will. If you have raised a question regarding subject matter jurisdiction, you brought it to my attention, I will take it under advisement and I'll determine if there is subject matter jurisdiction in this case.
Okay, and that would be, the subject matter jurisdiction would be validated after the case begins?
No, I will hear it as the case is progressing. What I've noted, what I will do, I'll note that you're objecting on that there's no subject matter jurisdiction. And if I find it, I'll let you know. If there is no subject matter jurisdiction, the case will be dismissed. You understand that?
Okay.
All right. Any other questions?
That should be it.
Okay. At this point, Ms. Collins, would you like to make any opening remarks?
Your Honor, I think I'll just call my witness.
Okay. Before you do that, Mr. Elmquist, would you like to make any opening remarks?
Yes, I would.
Okay.
I would like to let you all the testimony be made known. I believe it was on the October 10th when the original citation was written. And on that day, as my affidavit says, and also another eyewitness that has an affidavit that was supposed to be put on file. I believe it is on file there. But I was traveling north on Highway 51, and I stopped in front of that restaurant, the Benucci's, I think it's called.
Correct.
And, yep, I backed up and got stuck in the grass. And then I think it was at least 2 officer vehicles pulled up. So to my knowledge, no officer ever even saw my vehicle in motion. And since I neither changed lanes or changed direction, a U-turn would be absolutely impossible to do. So I did no U-turn, no Y-turn, and no eyewitnesses saw anything. There's no recorded video evidence because it did not happen. So I don't see how anything can even proceed unless it's going to proceed under abuse of process or sham legal process or malicious prosecution. Because there's no evidence, there's no eyewitness, so that means that there should be no case.
Okay. Go ahead.
I just said thank you.
Okay. Thank you. That will conclude your opening remarks. Ms. Collins, you may call your first witness.
I'd like to call Officer Craig Julsa. Close? Yep. Okay.
Mr. Julseth, please raise your right hand and repeat after me. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please be seated. State and spell your name for the record.
Name is Officer Craig Julseth. It's C-R-A-I-G. Last is J-U-L-S-E-T-H.
And Officer Julseth, what is your occupation?
I'm a patrol officer for the city of Stoughton.
And how long have you been a patrol officer for the city of Stoughton?
It's been a little over a year, since last June.
Do you have any other law enforcement experience?
I do have a year prior with the Milwaukee County Sheriff's Department.
Okay. And were you on duty on October 10th, 2018 at approximately 6:19 p.m.?
I was.
And what were you doing?
I was working as a patrol officer.
Where were you doing that work?
In the city of Stoughton.
Okay. And where specifically in the city of Stoughton?
Throughout the entire city until I received a phone call directing me to where to go.
And where were you directed?
I was directed to US Highway 51 and just north of Jackson Street. in the city of Stoughton.
And why were you sent there?
We received numerous phone calls for a school bus that was impeding traffic or in the shoulder of the road, causing bypassers to be worried for safety.
Okay. And is the location that you're describing located in the city of Stoughton, Dane County, Wisconsin?
It is.
Okay. And what did you observe when you arrived at that location?
I observed I believe it was a brown painted school bus, an international school bus, that was in the ditch next to Benucci's Bar and Grill, where the back end of it was closer to the restaurant. The front end was on the shoulder of the roadway.
And was the bus blocking traffic at that point?
It was on the shoulder of the road, just causing traffic to slow down.
Okay. And can you describe the roadway at that location, including how many lanes of traffic?
Yeah, that portion of the roadway is where it merges down from 2 lanes to 1 lane, and there's a median in the middle, and just past that where cars are merging into the single lane of traffic is where the bus was on the shoulder of the road.
Okay. When does the median end at any point?
It does.
And where is that?
It's approximately 50 feet, maybe shorter, south of where the bus was.
Okay. And what did you do after you arrived at the scene?
When I first arrived on the scene, I made contact with the driver and asked him what had happened.
And what did he tell you?
He told me that he was traveling northbound and saw a Walmart and decided to turn around, which caused him to end up where he was.
So Mr. Umquist specifically told you that he had attempted to turn around on that roadway?
That's correct, to go to Walmart.
Okay. And did you attempt to assist him in getting the vehicle out of the roadway?
It was stuck in the mud, so I called Schmidt's Towing for him to get the vehicle out, at which point he wanted a friend or someone he knew to come pull him, which would not have been possible.
Okay. And was traffic blocked while the towing was occurring?
Schmidt's Towing sent a large semi-tractor trailer tower, which we did have to stop traffic for the bus to be removed from the ditch.
And what did you do after the bus was removed?
Once the bus was removed, I had Mr. Elmquist go to the next street, which is Roby Road, where he was to settle up with the Schmidt's tow truck driver for the removal of the bus.
And what did you do after that?
After that, Elmquist was on Mr. Elmquist was free to go.
And did you issue a citation to Mr. Elmquist?
I did, for, I believe it was a legal mid-block turn, but it could be, if it's, yeah, I think it was an illegal mid-block turn.
And can you explain what that means?
It means you're attempting to turn around where you're not allowed to turn around in the middle of a block or interstate in that way, freeway.
So meaning where there's not an intersection?
Right,
Okay.
Yep.
And why did you issue the citation?
Based on what Mr. Elmquist told me he was doing, causing the traffic to slow down and causing us to have to stop traffic to get the bus out of the area, which is why I issued that citation.
I have nothing further.
Okay. Ms. Collins has concluded her questions. Mr. Elmquist, do you have any questions for this witness?
Yes, I do. I was wondering for the officer, do you not have the citation, a copy of it in front of you? Because if you said you believe it was a mid-block turn or mid-block citation, do you not know for certain what the citation was written up, what the cause of the citation was?
Correct, I do not have the citation in front of me.
Okay, because it was written up as illegal U-turn. Did you see that bus, the international bus, do a U-turn?
I did not.
Did you ever see the bus move at all, from north or southbound?
Via a tow truck I did, that was it.
Okay, so you didn't see any motion of the bus north or southbound just when it was being pulled by the tow truck?
That's correct.
Okay, and one other correction I needed to make, it wasn't their large heavy hauler tow truck, it was a smaller one, because the larger one was not needed.
Mr. Elmquist, now's the time. You'll be allowed to testify later. This is a statement. You are allowed to, you will give a chance to give your statement later. At this point, you are asking questions of Officer Joseph. Do you understand?
Yeah, okay, thank you.
All right. Do you have, sorry I interrupted. You may continue your questions of Mr. Joseph.
Okay. And Officer Joseph, the impedance that you saw happen to traffic, when did that occur chronologically?
Well, we received calls notifying to dispatch of the bus where it was located, so arguably 10 minutes prior to me responding to the scene.
Okay. And did you ever see the bus in any of the north or southbound lanes of traffic?
The bus was on the shoulder of the northbound lane where it was narrowed for the merging traffic, but not specifically in the lane.
Okay, so it was the bus, you never observed the bus in the lane, the traffic lane?
That's correct.
Okay. Do you have any video or pictures of the bus?
I'm not sure.
Okay. All right. I think that should be all for my questions. Thank you.
Okay. Ms. Collins, anything on redirect?
No, Your Honor.
Okay. With no further redirect questions, this witness is excused. Thank you, Officer Joseph. Does the city have any additional witnesses?
No, Your Honor.
Okay. That concludes the city's portion of direct examination. Mr. Elmquist, do you have any witnesses?
Are the two affidavits on file there?
I do have them in front of me. Generally, out-of-court statements are usually not admissible, but you can testify if you would like to.
Okay. So it would be kind of similar to the open statement issue then, or it would be testifying regarding to the material I just asked to the officer as well?
You can give testimony about what happened during this date if you so choose, and instead of a question and answer format, usually what works best is a narrative, if you want to tell me what you occurred. Now, it's up to you whether you want to testify or not. Would you like to testify?
Sure. And there's one other thing I didn't get to ask the officer, but I did bring up Walmart when I was talking with him, but it wasn't I was going to Walmart, I was coming from Walmart, which was south of the that location.
Okay.
So I mentioned Walmart, but it wasn't...
Mr. Elmquist, let me put you under oath, and then you can tell me your narrative story. All right. Are you in a position where you can stand?
Yes.
All right. Please stand and raise your right hand and repeat after me. Do you solemnly... Actually, you don't have to repeat after me, but I'm going to read you a statement, and then you can let me know if you swear as to the affirmation of the truth. All right. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Please tell the court, if you're standing, you may sit down or stand up. I'll give you your option. Please state your name and spell your name for the record.
First name is C-A-R-L, Carl, and then E-L-M-Q-U-I-S-T, Elmquist.
Okay. Mr. Elmquist, what would you like to tell me?
I would like to tell you, just similar to what I had mentioned in the opening remarks, but the bus that I have never was in the traffic lane impeding traffic, except for perhaps the tow truck when it was just pulling me out of the wet grass. But the desire was not to change lanes or do a U-turn, a Y-turn, or even a Z-turn, any kind of turn. The goal was to back up, make sure I was off of the traffic lane, and I was going to make sure and check my map for the direction I was going to be going. And the grass was wet, so I thought, well, if I backed up a little more, I could get a little speed and get out of there, and it had rained unbeknownst to me before that, and the grass was wet and soggy. So I ended up getting stuck, and I tried rocking it back and forth, which it got me back so far that then I was just done for and stuck, and I couldn't move anywhere. And that's when the officers came up. So, but I just wanted to make known that I did no U-turn, no Y-turn. I didn't block the traffic lane while traveling. I wasn't blocking or going across any lanes. And to do a U-turn, you have to cross traffic, and you have to change lanes, which I did neither of those. So to receive a ticket, and I didn't know this because I didn't get the ticket until after the whole thing. So when I got a ticket and I looked at it in the dark and it said illegal U-turn, I thought, what? But it was already written. I thought, this is disgusting because I did no U-turn. So I wish he would have told me that he would like to give me a U-turn. I could have talked to him and then probably resolved this issue alongside of the road or on a side road, but that did not happen.
Okay, is there anything else you'd like to tell me?
Just to make clear, I wasn't going to Walmart. I was coming from Walmart. So that was a chronological error in the officer's statement.
Okay. Anything else?
That should be it. Yeah, that should be it. So you have the affidavits on file. And those, did you say those, did you read those, or are you aware of the contents of those?
Let me read them right now. I typically do not read anything before court because I don't want to be prejudiced by any statements. So I will go ahead and read the two affidavits right now.
Okay. Thank you.
Okay, I have reviewed both statements then, both from you and from, how you say it, Elia Forster?
Yes.
Okay.
Correct.
Your Honor, I object to you relying on any information in Ms. Forster's affidavit as she's not here to be cross-examined.
Okay. Mr. Elmquist, your response?
Well, my affidavit still stands, and it says basically the same thing.
Okay. I will disregard Mr. the general affidavit from Elia Forster. It is hearsay. It's an out-of-court statement, and Ms. Forster is unable to be cross-examined.
Okay.
For the affidavit form, would you like that admitted into evidence?
Yes, please.
All right. I will mark it as Exhibit A. Any objection from the city?
No, Your Honor.
She says no, so your affidavit will be admitted as Exhibit A. Okay. Now, when the Mr. Elmquist, I'm going to turn this, Ms. Collins can now cross-examine you. You may proceed, Ms. Collins.
I have no questions for Mr. Elmquist.
Okay, then no cross-examination. Mr. Elmquist, do you have any other witnesses?
Not at this time.
Okay. Does the city have any rebuttal witnesses?
No, Your Honor.
Okay. We'll close the evidence portion of the case. Now we'll proceed to closing arguments. Again, Mr. Elmquist, Ms. Collins will go first, you'll go second, and since Ms. Collins has the burden of proof, she'll go last. You understand that?
Sure.
Okay. Ms. Collins, your closing remarks.
Your Honor, I ask that you rely on the testimony from Officer Julseth that he arrived on the scene and was told by the defendant that he was doing a U-turn to turn the opposite direction to go south towards the Walmart because he heard the statement contemporaneously with the incident in question, which provides the basis for him finding the citation against the defendant. And just to be clear from what they were discussing, it is sub C of the U-turn statute, which is a mid-block through any highway.
What statute is that?
So it's 346.33. And mid-block meaning, as defined in the statute, any part of the highway that is not an intersection, which was supported by the information that he received from the defendant and what he observed based on the direction that the bus was in the ditch at that time.
When you said C, that's subsection 1C.
1C, yes.
So it's 346.33 subsection 1C. Okay. Anything else, Ms. Collins?
No, Your Honor.
All right. Mr. Elmquist, your closing remark, please.
Sure. From what I've heard from the witness's testimony, also from the officer, that there was no mid-block the officer nor anyone else observed. There's no eyewitness to a U-turn or Y-turn, and the vehicle, it didn't block traffic, it didn't change lanes, and the nose was still pointed toward the northern direction. It never changed lanes. So there's no eyewitness to a mid-block, there's no eyewitness to a U-turn, and there's no eyewitness to a Y-turn. So without there's no evidence, there's no eyewitness in the case, so the case has to be dismissed for lack of evidence because there's no eyewitness to any of these charges.
Okay, I don't want to cut you off on a closing statement. Anything else you'd like to add?
I don't know if I can make a motion for dismissal, if that's not correct, but I would motion to dismiss it for complete lack of evidence and no eyewitness.
Okay, I will take that motion under advisement. Ms. Collins, anything on rebuttal?
No, Your Honor.
Okay, thank you. I've heard all.
Is there one more thing I could add to that statement?
Go ahead.
Also in the officer's statement, he even said that it was not blocking the traffic.
Okay, anything else you'd like to tell me?
That should be just that the officer even witnessed. It goes along with what I said, is that the bus did not block traffic. It wasn't in the lane of traffic.
Okay.
Thank you.
All right, thank you, Mr. Elmquist. Okay, now it's my turn. Now I'm going to make a decision based upon what is in front of me. So I've heard the testimony for Officer Joseph. I've also heard the testimony for Carl Elmquist. I've admitted Exhibit A, which is a general affidavit form that states from Carl Elmquist that he traveled north on Highway 51, stopped in front of Benucci's, backed up, got stuck in wet grass, and a tow truck hauled him out. Now there's some evidence about receiving a call from the prosecutor. I will disregard that part of the affidavit because that's general negotiations and that's not admissible. But I will, as Exhibit A, I will take the first paragraph about Carl Elmquist, and his testimony from the affidavit is consistent with the testimony I've heard tonight. Now, the relevant statute on U-turns is as follows. It's 346.33, subsection 1, which states, the operator of a vehicle may not make a U-turn upon a highway at any time of the following places. Now, C says, in mid-block on any through highway in a residential district, except where the highway is a divided highway and where the U-turn is made at an opening or crossover established by the authority in charge of the maintenance of the highway. All right. Now, I'll take testimony. The Officer Joseph testified that Mr. Elmquist said that he did a U-turn. Now, Mr. Elmquist, you've stated before that there was no eyewitnesses, but I can consider statements against the defendant's interest. And I find that that was a statement that Mr. Joseph said, Officer Joseph stated that you said that you made a U-turn. Given that is direct evidence, that does not matter that there was no eyewitness. And so if he did make a witness, or if he did make that statement, you were the operator of a vehicle, and it says you may not make a U-turn upon a highway, and I'll find that U.S. Highway is in the city of Stoughton. You are identified as the defendant, and it was Highway 51 is a highway of the state. According to Officer Joseph's testimony, it was mid-block on any through highway in a residential district. Now, it is a commercial district, but there's also houses there as well. Except where the highway is a divided highway and where the U-turn is made at an opening or crossover established by the authority in charge of the maintenance. I'll make the finding that there is no opening or crossover established by the authority. I will find that the city has met all its burdens under this offense. Now, Mr. Elmquist, you've argued that there was a motion to dismiss, there's no eyewitnesses. Testimony is valid evidence, and I find a statement against the interest is valid in this case. Given the fact that this was a valid statement and it was a statement against your interest, I will make the finding that the city has proved that you made a illegal U-turn contrary to 346.33, subsection 1, subsection C. I'll make that findings that they've proved their case by clear, satisfactory, and convincing evidence, and I will find that you're guilty of this citation. Now, at this point, I found you guilty, Mr. Elmquist. At this point, we'll argue the penalty of the citation. Ms. Collins.
Well, I object.
Your objection's duly noted, But it's my turn right now, and I'm gonna ask Ms. Collins for a forfeiture amount. Ms. Collins,
The citation amount is $98.80, Your Honor.
all right. Mr. Elmquist, what would be your argument for the citation amount?
Can you explain to me what that means?
The forfeit, they're asking for $30 plus costs, so the total forfeiture that the city is requesting is $98.80.
Okay. Wow. So, since because it wasn't a moving violation, correct?
No, it is a moving violation.
Because I know in the officer's statement, when he said it was on the way to Walmart, I know there was a confusion there in what either he remembered or jotted down, because the chronology of it was incorrect, because I wasn't going to Walmart. So I think the problem is the claiming of the U-turn is also an error, because the direction that he thought I was going is also a grave error on the charging instrument.
Okay. So,
That's the reason I objected. But
I understand. So, Mr. Elmquist, the forfeiture range on this is $20 to $40 with a bond amount of $30. I'll find that the $30 forfeiture of $98 plus costs for a total forfeiture of $98.80 to be appropriate. I will grant you I'll grant you 30 days to pay for the forfeiture, and I'll send you a notice. Now, Mr. Elmquist, if you feel aggrieved by my decision, you may appeal my decision either what's called on the record or by a de novo hearing. I'll have my clerk send you that form, basically a notice of a right to a trial. You have 20 days to appeal my decision from today. We'll mail that to you, and if you have any questions regarding the instructions, you can call my court clerk.
no, just a minute. Did you say de novo?
De novo, yes. De novo means for the first time.
Okay. And it would be heard by a different
judge,
different
correct.
judge?
Yep, a circuit court judge.
In the same location, or there's?
It would be in Dane County in Madison, Wisconsin. Dane County Circuit Court, at the Dane County Courthouse.
Okay. Is it possible, instead of having the forfeiture be that much, if it was whittled down to make it a little more accommodating, even though I did no U-turn or Y-turn?
We've already discussed it. I've already made my ruling that the forfeiture is $98.80.
Okay.
Is
So
your address? Go ahead.
The clerk of court, is that, what is her name? Or who would I call to get more information?
Her name is Mary Giemza, and I will have Mary send out a notice to you. Do we have your current address on file?
I believe so. It should be. It hasn't changed, so.
Okay, so it's the Otter Lake Road in White Bear Lake, Minnesota.
Yes.
Okay, we'll send notice of your right to appeal at that. We'll also send the forfeiture amount and when it's due, and we'll also send the notice of right to appeal to you as well.
Okay, and then just one question I had regarding you. Do you have, I think it was, what is that? It's the Minnesota or the Wisconsin statute of, I think it's 757, but regarding the oath of office, because you have an oath of office sworn on file according to statute, correct?
That's correct.
Okay. All right. I think that should be all. I will just have to contact Mary regarding some more information.
Okay. I will have her send all those documents. With that, this case of City of Stoughton versus Carl Elmquist is closed. Thank you, Mr. Elmquist.
Yes.
All right. Goodbye.
Okay. Very well.
Okay. Thank you.
Okay.
I'll let you know if we're going to Dane County.
All right. All right. Next case we'll call is City of Stoughton versus Susanna Kania. Yeah, thank you. Oh, thank you.
also for just power as well.
And Mary, I have the videos on a flash drive.
I thought you guys were bringing a laptop.
I have a laptop.
Could you, yeah, because then we have a connection.
Do you have them on there?
Well,
I do, but
we have it for both of you, where you could, if you have your laptop.
Oh, I do, yeah.
The cord is right there. Plug in.
Okay.
You won't have to.
Oh, I see.
HDMI.
Are you about to see what my computer looks like? It's my work. Luckily, it's my work computer. I don't have any strange picture up there or anything. But let me. Oh, I shouldn't have to connect to the internet.
Brandon is in charge of deciding which one is live. It's okay. IT is on there too.
And so I have the dash cam. My thought was to show all of the tests except the light, just because it's facing the wrong direction and it's not that helpful. But we can show
Do
it.
you need a minute?
Just seeing.
yeah, the dash cam, and then, yeah, as far as the light goes.
I'll
yeah,
do,
you
I'll,
just-
I'll recuse myself for,
Oh, sorry.
I'll leave for a
Okay.
minute while we.
Oh,
Sorry, with having the U-turn thing, I didn't have a chance to chat with you.
no, that happens. So, you wanted to show just the squad cam, and then for the light part,
For the eye test,
The eye
you
test,
just can't even really see it, so I thought just for time-wise, maybe skip ahead. But I'm fine with playing all of it. It's about 12 minutes for all of the tests if we play all of it.
yeah. Mm-hmm.
Get all the technology issues straightened away?
I believe so.
All right. Again, we'll call the case of City of Stoughton versus Susanna Kania. State your appearances, please.
Amy Collins O'Hara appears for the City of Stoughton.
Attorney Eric Habish appears for Ms. Kania.
Okay, the parties have discussed this case and negotiated and unable to reach a resolution. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
Okay. All right. With that, any preliminary, I'll note for the record that this is an OWI trial. It's also a judicial review of the administrative hearing. Is that also correct?
Yes.
Okay. Are there any other issues that I should be aware of before the trial?
There's also a speeding ticket.
Okay. All right. But no other motions or anything like that?
No.
Okay, with that, would the city like to make an opening argument?
No, Your Honor.
Defense, Mr. Habish, would you like to make an opening argument?
In the interest of brevity, no.
Okay, thank you. City may call its first witness.
Your Honor, I'd like to call Officer Paul Johnson.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please be seated. State and spell your name for the record.
Paul Johnson, Johnsson,
And what is your occupation?
police officer,
And where are you a police officer?
the city of Stoughton,
How long have you been an officer with the City of Stoughton?
approximately 4 years.
Do you have any other police experience?
I do.
Where is that?
In the city of Edgerton for approximately 2.5 years, and the area of Lake Geneva for 3 years.
And approximately how many OWI investigations have you been involved in during your law enforcement career?
Just over 50.
Okay. And did you receive training about determining whether someone is under the influence of alcohol?
I did.
When did you receive that training?
I graduated the police academy in December of 2010.
Okay. And can you generally describe the training that you received?
How to administer standard field sobriety tests on the roadside.
Okay. And did you complete any training in operating the intoximeter or any other?
Yes.
Yes.
Yeah,
And
we do that. I believe is it annually or biannually? Yes.
Okay. And did that training educate you on on the indicia of intoxication and impaired driving?
Yes.
Okay. And by completing the training, did you become certified to administer field sobriety tests?
I did.
Okay. And were you certified to administer those tests as of August 23rd, 2019?
Yes.
Okay. So I'm going to ask you a few questions about the morning in question, August 23rd, 2019. Were you on duty that morning at approximately 12:56 a.m.?
Yes.
Okay. Where were you and what were you doing?
I was in the area of Highway 51 and Whole Avenue in the city of Stoughton, Dane County, Wisconsin.
And what were you doing at that location?
Monitoring traffic for speeding violations and other traffic violations.
Okay. And is this intersection located in the city of Stoughton, Dane County, Wisconsin?
It is.
Okay. And what, if anything, did you observe at that time?
I observed a vehicle traveling eastbound on Highway 51.
Okay. And what did you observe about that vehicle?
I noted that the vehicle appeared to be traveling over the posted 25-mile-an-hour speed limit. I did check that vehicle speed with forward-facing stationary radar.
Okay. And what did you learn from the radar?
That the vehicle was traveling 42 miles an hour in a 25-mile-an-hour zone.
Did you notice anything else about about the vehicle at that time?
At that time, no.
Okay. What did you do then?
After the vehicle passed my stationary location, I safely pulled out behind it and began to follow the vehicle.
Did you notice anything out of the ordinary when you were following the vehicle?
As I caught up to the vehicle, I observed that the vehicle was making an S-type swerve within its lane of traffic as it traveled eastbound near 51 and Kingsland Road in the city of Stoughton.
And what did you do then?
At that time, I continued to follow it to observe other traffic violations.
And did you observe any other traffic violations?
No other traffic violations.
Okay. And then did you decide to pull over the vehicle?
I did.
Okay. And where was that?
That was, I initiated my overhead red and blue lights as it made a right-hand turn onto South Van Buren, just off of Highway 51, or in that spot, it's Highway 51 and West Main Street in the city of Stoughton.
Did you identify the driver of the vehicle as, tell me if I say this wrong, Susanna M. Kania?
I did, yes,
And how did you identify her?
by Illinois driver's license.
Okay. Did you tell the defendant why you were stopping her?
I did.
And what did you tell her?
I informed her I was stopping her for a speeding violation.
Did you ask her where she was driving from?
I did.
And what did she tell you?
She was coming from Madison.
Okay. What, if any, other observations did you make while you were speaking to the defendant?
I noted a moderate odor of intoxicants emanating from her breath. Her eyes were bloodshot and glassy, and she had slurred speech.
Okay. What did you do after having this contact with the defendant?
I asked her if she had consumed any alcohol.
What did she tell you?
She told me no.
Okay. What did you do then?
I informed her to stay in the car as I returned to my squad car and performed a records check.
And what did you learn from the records check?
That she had a valid Class D Illinois driver's license with no prior OWI convictions.
Do you recall how old the defendant is?
I do not.
Okay. Did you contact Stoughton Police or another officer at that point?
I contacted our dispatch and requested a backup officer, yes.
And why did you do that?
That's standard operating procedure for field sobriety testing.
Okay. Did you return to the defendant's car?
I did.
And what did you do then?
I asked her to step out of the vehicle, backing up. My first contact with her, she told me that I must be smelling something from inside the car when I questioned her on smelling alcohol. So at this time, I asked her to exit the vehicle and had a second conversation with her at the rear of her vehicle.
And what did you discuss?
I confirmed that she was coming from Madison, going to a farm in Stoughton. And again, I learned or observed that her eyes were bloodshot, glassy. She had slurred speech. And as she exited the vehicle, I noticed that she had taken a side step to her right to regain her balance.
Okay. And did you ask her again about whether she'd had anything to drink that evening?
I did.
And what was her response?
She again told me no.
What did you do then?
I informed her that it was in her best interest to be honest with me, and I asked her for her to be honest with me, and then she told me that she had 1 glass of wine and 1 glass of beer.
Okay. And was she specific about the wine or beer?
She was.
What did she say?
I believe it was red wine and some microbrew type beer. Without reading my report, I don't know.
Sure. And what did you do next?
I asked her to perform field sobriety tests.
And what was your basis to ask her to perform the field tests?
Based on the traffic violation, the S-type swerving within her lane of traffic, her admission to consuming alcohol, the bloodshot, glassy eyes, slurred speech, and the odor of intoxicants.
Okay. And did the defendant agree to perform the field tests?
She did.
And can you briefly explain to the court what the tests are and what they are used for?
The tests are 3 standardized tests: the horizontal gaze and nystagmus test, a walk and turn test, and a 1-leg stand test. They're administered the same way every time and we are trained to look for clues of impairment and then make our arrest decision based on the observations of those clues.
Okay. And what test did you first ask her to perform?
The horizontal gaze and nystagmus test.
Okay. And briefly explain that test?
It's commonly referred to as the eye test. It's a multiple left to right motions with a stimulus that the defendant follows with their eyes without moving their head, and we look for the onset of nystagmus prior to 45 degrees at maximum deviation and the lack of or smooth pursuit of the eyes.
Did you ask the defendant about her ability to perform the test?
I did.
And what did she say?
She stated something about being possibly legally blind in one of her eyes. She did state that she wore contacts, however, did state that she could see me, and I was standing approximately, 12 to 20 inches from her, and she stated she could see me and that she could see the tip of my pen light and identified that it was blue.
Okay. And what clues did you observe as part of the test?
I observed the lack of smooth pursuit in both of her eyes, the onset of nystagmus prior to 45 degrees in her left eye, and the distinct and sustained nystagmus at maximum deviation in both of her eyes were a total of 5 of the 6 possible clues.
Okay. Is it unusual to observe the onset jerkiness in one eye and not the other?
Is that unusual?
Mhm.
No.
No, okay. And what are the total number of clues that you look for in this test?
6.
And how many did you identify?
5.
Okay. What did you do next?
The next test I administered was the walk-in turn test.
And briefly describe that?
It's a series of a divided attention test where you ask the subject to stand in an instructional stance. We explain and demonstrate the test, and then we ask them to perform the test.
Did you ask the defendant if she understood the test?
Yes, I did.
And what did she respond?
She stated that she understood the test.
Did you ask the defendant about her ability to perform the test?
Yes.
And how did she respond?
She stated that her back possibly might hurt, I believe was her quote. And then again, she stated that she is clumsy, but stated that she is able to walk and turn in a normal type fashion.
Okay. And did you make any notes about her clothing or shoes?
She was wearing sandals the night of this incident.
And did you ask her about that?
I believe I gave her the option to leave them on or take them off, yes.
Okay. And what clues did you observe on that test?
I observed that she was unable to stay in the instructional stance, and then once she started the test, she missed heel to toe on multiple steps. She used her arms for balance, and she did a improper turn.
Okay. How many total clues are there to observe in this test?
There's 8.
Okay. And how many did you observe?
5.
Okay. What test did you complete next?
The one-leg stand test.
And could you briefly describe that?
Again, it's a divided attention test where you ask the subject to raise the foot of their choice approximately 6 inches off the ground while counting out loud by 1,000.
And did you ask the defendant if she understood the test?
Yes, and she did.
Okay. And how many total clues are you trained to look for on the web leg stand test?
4.
And how many did you observe?
3.
Okay. And what clues did you observe?
That she swayed while balancing, used her arms for balance, and put her foot down multiple times.
And was she able to complete the one-leg stand test?
No, the test is a total of 30 seconds. I stopped the test after approximately 30 seconds when she had put her foot down more than 3 times, so I stopped it for safety.
I'm sorry, when did you stop the test?
I believe she counted 13 1,000 and I had stopped the test for her safety.
So would that be about 13 seconds?
Yes.
Okay. And when you say for her safety, what do you mean?
Being that she was unable to, when she picked up her foot, she would almost immediately put it back down. I didn't want her to fall.
Okay. And on that morning, did you perform the 3 field tests we just talked about consistent with the training that you've received?
Yes.
Okay. Did you ask the defendant to complete any other tests?
I asked her to administer or perform the alphabet test.
And what is the alphabet test?
It's another divided attention test where we asked a subject to start in the middle of the alphabet and stop prior to the end of the alphabet to divide their attention.
And what did you ask the defendant to do?
I asked her to recite the alphabet starting with the letter D as in David and stop when she gets to the letter X as in X-ray.
And did you ask the defendant about her ability to perform this test?
I did.
And what did she say?
She informed me that she was fluent in the English language as well as a second language, which I do not recall, but she did have a bachelor's degree and was, again, fluent in the English language.
Okay. And how did she do on that test?
Without looking at my report, I can't read you right to what she exactly said, but I believe she ended prior to or skipped a couple letters prior to when she stopped.
Okay. And was the vehicle you were operating on August 23rd, 2019 equipped with a video camera?
It was.
And did the video camera capture the observation that you were just describing of the field sobriety tests?
Yes.
And how does the vehicle, or excuse me, the video in the vehicle start recording?
Once our overhead emergency red and blue lights are activated, or we can manually turn it on.
Okay. And you had it turned on for the field sobriety tests?
Correct.
Okay. So I'd like to show those, and I have the video queued up.
You want me to step aside?
I may need you to identify it.
Okay.
So what I'm going to do is, I've got it marked here when they start. See if I can get there without too much trouble. So just for the recorded record,
Miss Collins?
Yes.
O'Hara, Officer Johnson, if you want to drag the microphone closer to you, that way we'll be able to pick it up then.
Okay.
You can just
Okay.
leave it at the edge, and then we should be able to pick it up there.
okay. Officer Johnson, does that look like the video in question?
Yes.
Okay. So, Your Honor, with your permission, I'll play.
Any objections?
No, Your Honor.
All right, go ahead.
There should be sound.
Once I get out of the.
Oh, okay. Mm. Oh, I had it queued up. Here we go.
Oh, this is. Yeah, there should be sound.
Sorry. Okay. No. Officer, is this you first approaching the car?
This would be my second approach.
Okay. Oh, that's not what I meant to do. There we go.
Is your computer audio, or does it? Just want to be sure that you're not muted or something along those lines.
I mean, it's very possible, but no, I'm right here. It's showing that I've got. Yeah, does the sound go through the HDMI?
It should.
You think?
What we'll do is we'll take a break while the
Thank you,
IT
sorry.
director is fetching.
That's what I thought too, but actually that mutes it.
Yeah.
Were you planning to use it or no?
The what?
Were you planning to use the video if she
Yes.
switched over to you? Okay.
Yeah.
Anywhere else that I can? Is this where it would usually play? On that one?
Yeah, that one's
Okay.
off. Yeah, the in-car one is the one if you want to get rid of the stereo music.
Okay. What played am I off on? Yeah, that's right.
Let's give that a try. I mean, I unplugged the HDMI to do it, but let's see if I plug it back in and
See if yours can have sound.
yes. Okay, let me just make sure we're up and running here. All right, I just want to be sure I'm queuing it up to the right point. Where do we?
I had it at 105.
Run here?
All right, this looks like
I
it's the
think
right
it's,
speed.
yeah, I think yours is working.
I thought they were walking a little
I
slow.
was gonna say, what was going on with you guys? Yeah, right. Oh, and we got him out.
Yeah, it just turned on there. But it's, yeah, you should have heard me put it in my pocket.
So we've actually got it on his now. We were trying that.
I mean, it played when I was not connected to the HDMI, but I think when I connected it, I couldn't get it to
Once
hear.
you're connected to the HDMI, it's probably going to override your.
Just something not synced up or
Well,
something. Or, I'll let you.
You're on mute there.
Turn up. Oh, you can turn it, yeah. No such luck.
Doesn't look like it's happening.
HDMI carries video and sound, so it should bypass the computer. But the thing is, though, this has no audio in it. Yeah, because it's not plugged into HDMI. Yeah, no, that one didn't work. There's nothing. It works if you don't plug the HDMI in.
That's what I was just
It has
thinking,
audio versus
possibly.
video.
Yeah, right.
Yeah. Because that's pretty much all we do. If we plug in an HDMI into a HDMI VGA converter and then plug in that audio on it, but we don't have anything that's going to output it.
Are we the first ones to try to use a video in a while? Okay. Is there an easier way to do it in the future? You put it on a disc or something?
Well, then we would need a laptop to put it in.
Yeah.
We would project it
And
to a
so
big
many of them
TV.
don't even have that anymore.
Yeah, BD's up. Nope.
Sounds like it won't work to project it, like if you can play it on your laptop.
Well, I was gonna say, what we could do
But then
is,
it's, you know,
yeah, or I don't need to see it. I could put it up there and then you could make sure that I wasn't playing anything that you hadn't already seen. I don't really need to ask the officer questions about it. I just wanted the court to see it, so.
Yeah, both of you play it, one unplugs.
But we'll have to sync up correctly.
Yep.
Make sure to put up the microphones out by it, because it won't.
Oh, I see. I see what you're saying. Yep. So let me see if it will play when I. Mine doesn't want to have sound. There we go.
Click on the in-car one. Oh, it's
I'm
frozen.
all
Sorry, it's freezing on me. Sorry, mine's frozen.
Yeah, me too.
Yeah, this whatever system you guys got, my computer does not like.
All right.
Not playing
I'll turn the
nice.
lights back on.
See if I can just try and reboot it and then sync back up.
Okay.
It's like 30
I got it
seconds
to do
delayed.
something.
Okay.
Well, I tell you what. Why don't we take up questions of the officer? If you both agree on the video, why don't you just submit it to me and I can review it and then just issue a written decision? I think that'd
Yeah,
probably be
I
the
think that's
best way.
Okay. I mean, I had questions that I had to refer to some of the audio in there, like,
Okay.
as part of that. So, I mean, it's,
Well, see, is there my understanding is that the the court software is not going to jive with your laptops. Is that right?
yeah, I mean, it doesn't seem like it. I mean, I can,
I'm sorry, what was that? Oh.
I mean, I am at 105 now, and then if we could sync it up, we might
Okay.
be, I
Why
might be
don't
able
you
to get the video.
take your time then syncing it up. Then if you're going to ask questions regarding the audio, we'll do it now then.
All right,
So give me, but mine,
sure, I'll let you.
He had to log out of it and come back.
did I?
Yeah.
Yeah, that might be what we have to resort to.
There we go. Okay.
All
All
right,
right, it looks like it'll play.
all right, I'm at 105 even.
Me too.
All right,
1, 2, 3, play.
go.
All right, ma'am. Can you go ahead and step out of the car for me? I just want to chat with you at the back phone. So if you pause it for a second.
Mine says 55. Oh, that might be slightly off.
You can leave all that stuff in the car if you want.
Probably close enough.
All right. So you come from Madison?
Yeah.
Okay, and you said what's the address you're going to?
I'm going to 1386 the County Rest Road, Weston.
Okay, and who lives there?
My supervisor lives there, but I'm farm sitting for her.
Oh, okay, I understand. Okay. All right, so how much have you had to drink tonight?
Nothing.
Be honest with me, okay? This isn't the first night on the road. So will you do field sobriety test?
What?
Will you do field sobriety test?
Sure.
Because I think you've been drinking. Am I? You had a couple drinks?
Okay, fine. It was hours ago.
Okay, all right. So,
hours.
all right, so we're gonna start over, okay? So lying to me isn't gonna get you anywhere. Honesty is gonna get you where we need to go tonight, okay?
Okay.
So just be honest with me. If it was a couple hours ago, you had a few drinks, not a big deal, okay?
Okay.
We'll run you through field sobriety test. They'll be able to tell us, you know, if you're impaired to be driving a car, okay? So how long ago was your last drink?
I don't know. I don't keep track of time.
Okay, what time is it now, do you think?
It's 1 a.m.
It's 1 a.m.? Okay. So if it's 1 a.m. now, when was
Yeah,
your...
it was a couple hours ago. It was like 11 p.m.
11
It was
p.m.?
10:30 p.m.
10:30 p.m. was your last drink, okay. And that was in Madison?
Yeah.
Okay. And what were you drinking?
It was beers.
Beers?
Yeah.
What kind of beers?
There was a hibiscus sour.
How many of those did you have?
One.
One. Anything else?
Probably.
Probably.
Yeah.
Same beer or different beers?
There was red wine.
Red wine?
Yeah.
Okay. Anything else?
No.
Any shots of liquor or anything like that? No, okay. And so, but your last drink of either the beer or the wine was at 10:30 tonight? Okay.
Yeah.
How many glasses of wine did you have?
One.
Just one? So one glass of wine, one glass of beer?
Yeah.
Okay. Or was it a bottle or a can of beer or whatever?
Yeah.
Okay. All right. What time did you leave Madison?
Well, if it's 1 a.m. now, been driving a while. Midnight, probably.
Okay. All right. And you'll do some field sobriety tests for me? Okay. All right, why don't you just hang out here with my partner? I'm just going to turn a couple lights off. I'll be right back up.
Where you at right now? I think we're a little more out of sync.
Oh, yeah. 108.51. Oh, it says it's the same. So who's faster, him or me? Okay. Pause and restart.
That's true.
Yeah, you should be closer. 41, I'll be out with the field.
Yeah, I'm way
All right,
faster.
ma'am, if you can just step down here for me, we're going to walk down to my squad car here. All right. What I want you to do is just stand right here on my light. Okay, face me. Okay?
Yeah.
I don't know how you want to.
Oh, careful there. Okay? Keep your arms on your sides, put your feet together, toes to toes, heel to heel, just like that. Stay just like that for me,
Where are
okay?
you at right now?
Anything wrong with your eyes? Or contacts or
Trying to
glasses?
get back to
I wear
some.
contacts. I'm like almost blind in my right eye.
I think so too. And the problem is it's
Okay,
like
can
a
you see me?
10-second delay.
Okay, you have both, you have your contacts in?
Yeah, I have my
Okay,
contacts in.
perfect, okay. All right. Are you able to see the tip of my pen light?
Yeah.
Okay, what color is it?
It's blue.
Okay, so what I want you to do is...
So right there is where I was at.
Yeah.
So if you back up a little bit further.
That's a lot.
It's not very precise.
So there's where I'm saying stand here on my flashlight. What you do is I want you to follow the pen, the tip of the pen where it's blue, with your eyes and your eyes only. Do not move your head. Do you understand that?
You're way ahead of him, Paul.
Yeah, it's fun. That's how long it takes.
Now you might be close.
I think it's off by about 3-4 seconds. But I can see it.
Nobody would be talking.
Oh, just your head, just your eyes. Don't move your head. Okay?
I don't think it's working. I think we're gonna have to put it up there.
Yeah.
Okay.
Right.
Oh, now you wanna? That's helpful.
Mine or yours, or I wasn't sure.
You've already got yours up and running, that's fine.
Yours is faster, it looks like.
Yeah, mine's.
How far back am I going here?
I'm not so much concerned about seeing the eye test since we're faced the other direction, so
Let me see.
I'm fine with just starting here.
Still the eyes.
Okay, this one's gonna go up. Same thing, just follow with your eyes. You understand? Nope, just follow up.
And then if you hit that, we won't hear the country music.
Oh, that's right.
Okay, what color is it? Did it follow the pen? Okay.
Oh my God.
Yeah, it's jumpy. You can't
Yeah.
pick a spot. It's on our end too.
Okay, this one's gonna go up. Same thing, just follow with your eyes. You understand?
All right, I'll use this time to get in position.
Okay.
That way, by the way.
So about 10:30 was your last ring? Okay. All right. Anything wrong with your hips, knees?
Battery midway.
Oh, there's actually one right behind his chair.
Nice.
And then I would stop it at 116.
It's at 111 right now.
Yeah.
Oh, well, this is where he's asking the questions before the walk and turn.
Yep.
That's where I had, where the next step happens, but just keep an eye out for it so we don't hear anything we shouldn't.
So you want to stop it at 116?
That's what I had clocked in my office.
Okay.
Preliminary breath test, okay? Okay, everything is now. All right, so this is called a...
So that's where you want to stop it?
116.08. No, I'm at half speed.
All right, so this is called a preliminary breath test, okay?
Yeah, that's
Will
where
you
you should stop it there.
provide a breath
That's where I
sample
should stop
into
it?
this
Stop
little
it,
device
yeah.
here for me?
Oh, okay.
I was trying to make sure we didn't hear any of that.
She wanted to stop at 116, so we didn't hear that.
Oh, the end point of 116.
Yeah.
Sorry.
Just so the court didn't hear anything, the court should.
I didn't hear.
Good, yeah, no, there wasn't any.
There wasn't the results there. All right, so I'm gonna try and get it back to
1, 10, 11.
post the eye test, yeah.
don't move your head, okay?
That should be in
111 there.
Just close enough. Sweet. Oh, now it's gonna reload if you do that. Oh, now it's slow again. Is it slow because it's on the big screen?
It might be.
That's where I can see it on the small screen.
Okay, all right, so we'll try and get back to that.
Okay, this one's gonna go up. Same thing, just follow with your eyes, you understand? Oops, just fire it up. Okay, okay. Alright, so about 10:30 was your last drink? Okay. Alright. Anything wrong with your hips, knees, or ankles? Any medical problems? Sports injuries?
My back constantly hurts.
Okay.
My knees hurt when I go upstairs.
Okay.
It's
Okay, you can normally walk without a problem, walk and turn without problem, typically?
I trip all the time.
Okay.
Mostly I'm unsteady when I'm dead sober in church.
Okay, alright. Alright, so what we'll do is just try the best you can on the next test. It's a walk and turn test, okay? You wanna try? Okay. Alright, you got flip-flop or like sandals on? Okay, are you good with those?
Yeah.
Okay. Alright, so the first part of the test, what I want you to do is I'm going to back up so you can see my feet. Can you see my feet?
Yeah.
Okay. What I want you to do is take your left foot and place it out on an imaginary line in front of you like this. Okay? Okay. So now take your right foot and place it in front of your left foot, heel to toe. Keep it staying just like that. Keep your arms on your sides for me, okay? So stay just like that while I demonstrate the rest of the test, okay? Do you understand? So don't move, okay? I'm going to move away so you can see me a little bit, okay? So once I tell you to start the test, what I want you to do is take 9 heel-to-toe steps down the line, turn around how I demonstrate, take 9 heel-to-toe steps back, okay? Counting your steps out loud, watching your feet as you walk, keeping your arms down at your sides, okay? It's going to look something like this. Can you watch my feet? 1, 2, 3. Leave your front foot on the line. Take a series of small steps to turn around. Take 1, 2, 3 steps all the way up till 9. I took 3, but you're going to take 9. Do you understand that? Okay. So keep your arms on your sides. Once I tell you to start the test, don't stop until you believe that the test has been completed, okay? So look at your feet, count your steps out loud, keep your arms on your side, take 9 heel-to-toe steps down, turn around how I demonstrate, take 9 heel-to-toe steps back. Do you understand? Okay, you may begin. Okay, you can relax. Alright, so the next test, I got one more test for you, okay? It's a one-leg stand test, okay? Same thing, I'm going to show you how to do it, and then I'm going to ask you to perform it, okay? So just keep your arms on your sides, feet together just like you are, okay? So once I tell you to start the test, what I want you to do is raise the foot of your choice approximately 6 inches off the ground, keeping your foot parallel with the ground. Count out loud by looking at your raised foot, 1, 1,000, 2, 1,000, 3, 1,000, 4, 1,000, and so on, okay? Do you have any questions about the test? I'll wait until I tell you to stop. So it's approximately 30 seconds, but just keep counting until I tell you to stop. Any other questions about the test? Okay, so foot of your choice, 6 inches off the ground, arms down at your sides, looking at your raised foot, keeping your foot parallel with the ground, count out loud by 1,000, okay? Hold on 1 second here. All right, you ready? You may begin. Okay, you can relax.
I haven't worked in that. Sorry, something not that long.
Okay. All right. Do you read and write the English language?
Yeah.
Is English your first language?
Polish first.
Okay. Okay. Have you had any, what's your highest level of education?
I got my bachelor's in genetics undergrad.
Okay. All right. So you know your English alphabet?
Yeah.
Okay. Not going to have you say it backwards or anything like that. What I want you to do is start with the letter D as in David and stop when you get to the letter X as in X-ray. Just D to X and stop. You understand? You may begin.
DEFGHILNNOPQRSTUS.
Okay. Perfect. Very good.
That's where we're gonna stop.
All right. So this is called.
All right, Officer Johnson, did this video accurately depict the observations and field sobriety tests of August 23rd, 2019?
Yes.
Okay. Your Honor, I'd like to admit the video as an exhibit. I know you don't have a copy. Is that fine?
Any objections?
No, Your Honor.
Yeah, if you, we'll admit the video as Exhibit A, this will be the first one, and then you have a disk drive, or does anybody have a disk that I could use?
I have the, what are these called?
Flash drive.
Flash drive.
Yeah.
I did send a Google Drive or link last week.
Okay, and I'll note in the exhibit up through what was on the video at 1 hour and 16:05. Is that right?
Yeah, so it's 1 hour and 5 to 1:16.
1 hour 5 to 1:16. And by stipulation of parties, that's the time frame, correct? 1:05 to 1:16?
For the field sobriety tests, yes.
And the court is not to look beyond 1:16 unless you further identify what.
You may use some other time period.
No, I don't think I have anything
Okay.
offhand as far as that goes.
I won't use any other portion myself.
So we'll limit the video Exhibit A, 1 hour and 5 minutes to 1 hour and 16 minutes.
Thank you. Officer Johnson, after the events that we just saw depicted in the video, what did you do next?
I administered the PBT.
Okay. And based on your observations of the defendant's overall appearance and behavior, her performance on the field sobriety tests, did you form an opinion about whether she was under the influence of alcohol?
I did.
And what was that opinion?
That she was under the influence of alcohol.
And did you base that decision on just one clue or on just one field sobriety test?
No, the totality of everything up until this point.
Okay. And can you just repeat for us what some of those considerations were?
Yes, the speeding violation, the S-type swerve while traveling eastbound on 51, her admission to consuming alcohol, my observations of smelling the alcohol, her bloodshot glassy eyes, surge speech, 5 clues on the horizontal gaze and segments test, 5 clues on the walk and turn test, 3 clues on the one-leg stand test, and the few mistakes on the alphabet test.
Okay. And what did you do next?
I did place her under arrest for operating while under the influence.
Okay. And did anything need to happen with her vehicle?
Yes, it was parked too close to the crosswalk, so she gave Officer Covarrubias, who can be seen in the video, permission to back the car up approximately 10 to 15 feet so it was legally parked.
Did you note anything in her vehicle?
Yes, prior to moving it, we did conduct a search of the vehicle. Noticed that there was a lot of boxes and household items. Did note that there was 2 empty bottles of wine on top of everything in the back seat.
Okay. And did you then go to the Stoughton Police Department?
Yes.
Okay. And after arriving there, what did you do next?
I issued her a citation for operating while under the influence, first offense.
Okay. And what did you do next?
Brought her into our interview room and read her the informing the accused form.
Okay. Your Honor, may I approach?
Yes.
Do you recognize this as the informing the accused form that you used on that evening?
Yes.
And what time was that signed?
At 1:47 a.m.
And do you recall when you first pulled over the vehicle, approximately?
I don't.
Okay. And did you read that form verbatim to the defendant?
I did.
Okay. Your Honor, I ask that this form be moved into evidence. Or,
No objection.
It's been marked as Exhibit B and it's been admitted.
thank you.
Let me remark that. No, I'm sorry. I thought we covered up the informing the accused. Court's mistake.
And what did you do after going over the form?
I asked her if she would submit to an evidentiary chemical test of her breath.
And did the defendant agree to the chemical test?
Yes.
Okay. What did you do next?
Performed the 20-minute observation period.
And do you recall when that would have begun?
I would have begun at the same time that this form was signed at 1:47 a.m.
Okay. And what is the purpose of the 20-minute observation period?
To remove, we checked the subject's mouth to make sure there's no foreign objects in there. And for that 20 minutes, we observed that they don't drink, smoke, or regurgitate or drink any alcohol during that 20 minutes.
And was there anything in the defendant's mouth when you checked it?
There was not.
And during the observation period, did the defendant eat, drink, regurgitate, or vomit?
No.
And what happened next?
Then she was escorted a few feet away to the intoximeter area.
And what is an intoximeter?
It's a instrument where a subject provides breath samples into it, and it gives us a blood alcohol content reading.
Did you receive training on how to operate the intoximeter?
I did.
What department administered the training?
The Wisconsin Department of Transportation.
Okay. Did you successfully complete that training?
Yes.
And by completing that training, did you become certified to administer the chemical breath test?
Yes.
When did you become certified?
Would have been the early part of 2014, and then, like I said, I think we're recertified biannually, I believe.
Okay. And you were certified to administer the chemical breath test on the intoximeter as of August 23rd, 2019?
Yes.
And approximately how many of these tests have you administered? Approximate.
35.
Okay. And you administered this test to the defendant?
Yes.
Okay. And what time did you administer the test?
I'd have to look at the
Okay.
sheet, the printout.
Let me. You got it. Yes. May I approach? Yes. And Your Honor, I do have the maintenance test. Do you take that separately, or would you like the officer to testify to it?
I'll take those separately. That's okay. Any objections?
No.
I've got a copy for you.
Sure.
We'll mark the maintenance reports collectively as Exhibit D, and then the intoximeter reports Exhibit C.
Officer, I'm showing you what's been marked as, or if you could look at what's been marked as Exhibit C. Can you identify that?
Yes.
And what is it?
It's a intoximeter subject test report.
And does your signature appear on that document?
It does.
Okay. And could you take the court line by line through the test sequence and just talk about what all of those, what all of these mean?
Yes. I guess about halfway down says start test date and time. This test was started on August 23rd, 2019 at 02:12 hours. At that time, the instrument does a diagnostic test, which is that DIAG. As you can see, it passed that test at 212. Then it does a blank check where it takes a sample of the air that is around the instrument and checks that for any alcohol. As you can see, it shows a reading of 0.000. At that time, the instrument requests a subject sample, which would be Miss Susanna. So she provided an adequate breath sample at 2:14 a.m., which showed a result of a 0.083. After that subject test, the instrument then again tests the air around the instrument for alcohol, and again shows the blank check. That's or BLK stands for blank check, which is a result was 0.000. The next line is ACC, which is an accuracy check. It takes a sample of a known gas, which is just above all this, a dry gas target, at 0.08. It tests that known gas, and accuracy check showed a 0.079 reading. Again, then it pushes that out of the instrument and again samples the air around the instrument for another blank check, which showed 0.000. At this time, it takes the second sample from the subject, which Ms. Susanna provided an adequate sample, which showed a reading of 0.083. And then again, it checks the air around the instrument again and as a blank check and reported a 0.00 reading. And then finally, it does a diagnostic test again, and it showed that it passed that test at 2:20 a.m. At the end of that, you can see a reported value. What the instrument does is it drops the third digit and shows a reported value of 0.08 G/210L. And then you can see that I autographed it as the observer and the operator of the instrument.
And the defendant was able to give 2 adequate breath samples?
Yes.
Okay. And is the 0.08 value from the intoximeter above the prohibited or at or above the prohibited alcohol concentration?
Yes.
And what happened after you administered the test?
I issued her a second citation for operating with a prohibited alcohol concentration first offense.
Okay. And I'm sorry, if you could look at Exhibit D, do you recognize that document?
Which one was D?
That's the maintenance test.
That I don't have.
Oh, is that not up there? Let me give you one. And do you recognize that document, or have you seen documents like it?
Yes.
And is that a maintenance report for the specific intoximeter that you used on August 23rd?
Yes, the serial number matches.
Okay. And that document just shows that the machine was working properly on that date?
Objection, speculation.
That's fine. I think the document speaks for itself.
Objection overruled.
Can you repeat the question?
Can you just tell me the purpose of that document?
It's labeled as a 120-day maintenance test. As an operator, I don't do the maintenance test, so I don't see these at all or often.
Okay. And after you issued the third citation, then what did you do?
I read the, not the informant accused, the alcohol influence report to the subject.
Okay. And after that?
I provided her with the notice of intent to suspend and the administrative review paperwork.
Okay. And based on your entire contact with the defendant throughout the night, did you form an opinion about whether she was under the influence of alcohol enough that her ability to operate the vehicle was impaired?
Yes.
And what was that opinion?
that her ability to operate a motor vehicle on Wisconsin roadways was impaired due to alcohol consumption.
Okay, and that was at the time that she was driving the vehicle and was pulled over?
Correct.
I have no further questions.
Housekeeping before we get to Exhibit C and D, they've been marked, or are you offering them in the evidence?
Yes, Your Honor.
No.
Exhibit C and D are admitted. Mr. Abbott, you may proceed to cross-examination.
All right. Okay, I'm just trying to think of the best way to do this, given some of the technical issues we're struggling a little bit with. Because I have some other just visual documents, PDFs.
Okay.
So I'm going to bring them back over to there and see if we can just view them as far as that goes.
Okay.
I don't quite have all the printouts here, so I want to be. All right, you mentioned that you've received extensive training in the area of OWIs throughout your career, is that right?
Yes.
And those, and as you get certified over the years, and you recertified, those records will be updated at your department, or at the Stoughton Police Department now, but at whatever department that you've been at currently.
Correct.
Okay. So to your knowledge, the records that would come up there, that if one were to make an open records request from there, your certifications that the Stoughton Police Department would have in file would all be available?
Correct.
Okay. Try to lay the foundation for this document here. Would Lieutenant Patrick Conlon be one of the people who would oversee those records?
Yes.
Okay. Sorry, I was going to have this email queued up. I was running with the other issue. Oh, yeah, that's right. I can't. Internet issues. Okay. I have it here on my phone. I don't know.
Do you want? I have a hotspot.
Okay. Let's see if I can connect to it.
Can't you make a password? So it'll come up as Amy's phone. We have to come up like Amy's iPhone, something like that.
Mobile hotspot. Let's see. No, it's not. Come up here.
So I tried to turn it off and on one more time. That's what I do with mine. It shows up eventually.
Amy's iPhone.
Yeah. And then the password's right there.
Okay.
Oh, good, it's not showing. Let's not look at the password I picked when I was like 10.
disconnect for 1 minute, just so we don't see other
Certainly.
inbox items. Open a new window. All right, let's plug him back in. All right. Is that P. Conlon at City of, that's CI, Stoughton? Is that email address one that you recognize as Lieutenant Conlon's?
Yes.
Okay. So you, and you would be the P.J. Johnson he'd be referring to here. There are no other P.J. Johnsons at the Stoughton Police Department.
Correct.
Okay. So now, with your permission, I am going to open up the OWI-related training attachment. Okay, and this document shows you're completing the SFST block at Blackhawk Technical College around 2010, is that right?
Correct.
Okay. Your sensor FST training 2011. Oh, this is the one. Okay. Now, could you inform the court what this document is, this chemical test permit document?
This is the chemical test permit that was issued to me once I completed the training for the intoximeter.
Okay. And I wanted to just note for the record that there is an expiration date on this card, is that correct?
I believe so, yes.
I can zoom in if you need me to. See it better now?
Yes.
Okay. And that date is 31st of March 2015.
Correct.
Okay. And I take it you have been since recertified and reissued a chemical test permit since?
Yes.
You have that on you now?
No.
Okay. To the best of your knowledge, would it be available, would it be part of this records request?
Yes.
Objection. He doesn't know what was requested.
Why don't you lay a foundation?
Sure. Get back to the email. Would a records request regarding your OWI-related training reveal that permit test, or that permit card?
Yes.
Six documents. We're on the third one. Fourth one. Oh, and then this document, 5 out of 6, is your certification through an A-RIDE course in 2015.
Yes.
Have you had an A-RIDE course since then?
No.
And this document shows your ALCO sensor FST training on May of 2015.
Correct.
Okay. So what I have here are 6 documents, and I know I'm sort of scrolling through them a bit fast, but the latest of them appears to be dated May 5th of 2015. Would you agree with that statement?
Yes.
Okay.
Counsel, could you go back to who sent the original email that you referenced?
Sure, absolutely. This is from Lieutenant Patrick Conlon.
Thank you.
So it would appear, based on the request, that either the Stoughton Police Department's files are out of date, or the other conclusion that could be drawn is that the training, that you have not been recertified since 2015. That it would be either of those two options. Either the Stoughton Police Department do not have complete records, or that you haven't been recertified since 2015.
Objection, speculation.
Overruled.
Can you repeat the question?
Sure. So, would it be fair to say that, there are two possibilities in that either the Stoughton Police Department's records are incomplete, or that you have not been recertified, or that you have not undergone any certification courses since May of 2015?
They appear to be incomplete, yes.
Okay. Let's cycle back to the training that, we have confirmed that you've taken. Start with the A-Ride manual. Let me just... Actually, we will scratch that. Just going to disconnect here. One portion of your A-Ride training stressed to make complete and accurate reports. Is that correct?
Correct.
And I believe there's one slide, correct me if I'm wrong, if you didn't write it in the report, it didn't happen. Would that be an accurate summary of one part of that training?
No.
Okay. Or maybe I'll rephrase, if you didn't write it in the report, all right. Let me just...
Mr. Havich, sorry to interrupting. Are you going to refer to the video soon?
Yes.
Okay. All right. No, I was going to ask to turn on the lights on, but I'll leave them off for now.
Okay. Let me... pull it back. All right. That's right. I can't just reconnect and do that. I have to actually bring that up. All right. Let me just... get it queued up to a proper point here. To your recollection, during the horizontal gaze nystagmus test, do you recall if there were any passing cars passing by you on that street during that test?
I believe we observed one in the video.
Okay, and that was during the eye test?
I believe so.
Okay. And as part of your training, you are trained that there are various causes of nystagmus, that they are not all alcohol related. Is that correct?
Correct.
In fact, one type would be optical kinetic nystagmus. Is that correct?
That's correct.
And that can be triggered, among other things, due to other sort of external stimuli, flashing lights, and so forth. And that's one of the reasons why sorry, it can be triggered by external stimuli such as flashing or moving lights.
Correct.
Okay. And that would be one of the reasons why you turn off your emergency flashers, your front-facing flashers, when you're conducting these tests.
Yes.
So you would agree that flashing lights or moving lights can cause, can disrupt the validity of these tests?
No, because we're looking for vertical nystagmus, or horizontal gaze nystagmus. We're not looking for optokinetic like you're referencing.
Right, but if one, if there's one type of nystagmus that happens, during the test, and, in terms of, nystagmus can happen, like I said, you've agreed that there are multiple causes of nystagmus, correct? That there are multiple causes of nystagmus.
Right.
And that optokinetic is one of them.
Yes.
Okay. An optokinetic nystagmus can be caused by flashing or moving lights.
Yes.
Okay. And so, absent, removing all sort of flashing and moving lights, from the scene completely, you can't, there would be times where optokinetic nystagmus can happen or influence the result of your test.
It could, but didn't.
So are you saying that a passing car could have an effect on your test, but it didn't in this case? Is that your testimony here today?
It didn't because she was concentrated on my stimuli and not the passing car.
You would agree that when someone is focused on an object, they can see other items around them in their peripheral vision.
Yes.
Okay. And that the human eye can sort of track movement involuntarily, just sort of as a reflex action.
Sure.
Okay. So it's possible that someone being focused on a stimulus could have their eyes react to something external to that stimulus while still being focused on that stimulus.
Yes.
Okay. Now, you noted that you've made about, you estimated roughly 50 OWI investigations.
Correct.
And about how many of those have you performed the horizontal gaze nystagmus test?
Every one of them.
Okay. And about how many would you say that you came up with an odd number of clues?
I don't have that data.
Would it be more than 10, less than 10?
Without looking at my record sheet, I don't even venture a guess.
Okay. All right. But you recall that it has happened?
Yes.
Okay. Would you know how frequently it's happened throughout that time?
I don't.
Okay. You noted that Ms. Kania, in your interview with Ms. Kania, she explained that she did wear contacts. Is that correct?
Correct.
And that's one of the questions that you are trained to ask for before the horizontal gaze nystagmus test.
Yes.
Now, would that be because that contacts can influence the outcome of the test or have an effect on the outcome of the test?
If they're hard contacts or cosmetic contacts, they could.
Okay. You did not ask the nature of her contacts. You just asked whether they were in or not.
Correct.
Okay. Do you wear contacts, officer?
No.
Do you know anybody who does?
Yes.
Are you aware that wearing contacts for a long period of time can cause irritation in your eyes?
Yes.
Okay. And some of that irritation can, and that contacts themselves they do have a sort of reflective nature to them in that they're glass or plastic and they have, light goes through, but it can also reflect off of them.
Yes.
And so that could contribute to a glassy-eyed appearance.
Yes.
Turning to the walk and stand, or the walk and turn test, Ms. Kania noted several, listed off sort of several, you asked Ms. Kania if she had any sort of potential injuries or possible issues with performing the test, is that correct?
Yes.
And she listed that that her back hurt.
Correct.
And that she had issues with her knees when going upstairs, I believe.
Correct.
And that she ordinarily trips over her own feet, I believe, even in her words, even when sober in church.
Correct.
Okay. So you were aware of all these conditions and took them into account during your test?
Correct.
And in what manner did you take them into account?
That she had stated that those were some of her concerns while performing a walk and turn test.
Okay, so you noted them.
Yes.
And you proceeded around the test. You proceeded to do the test. Proceeded to have Ms. Connie perform the test ordinarily.
Yes.
Okay. You also mentioned that you wore sandals. Is that correct?
Correct.
And that you had asked her whether or not she was okay to do the test in those sandals.
Yes.
Okay. Have you ever performed a walk and turn test in sandals?
No.
Would you agree that it would be more difficult to perform it in sandals versus regular shoes?
I don't know because I've never tried it.
Okay. Have you ever tried to do it in bare feet?
No.
Okay. And some of those same issues in terms of her back and knees and some of the conditions that she alluded to, those are also other things that can influence the outcomes of the one-legged stand test. Is that right?
Yes.
Okay. And so again, you noted those concerns from earlier, but still had her do the test ordinarily.
Correct.
Okay. Now, turning over to the 20-minute observation period that you observed Ms. Kania.
Yes.
You're indicating that it began shortly after that you had read her the implied consent form. Is that correct?
Yes.
And you had that form in front of you, and that time is indicated as 1:47.
Correct.
Okay. And so you were in the room the entire time.
Yes.
Is that correct? Okay. And you were watching Ms. Kania.
Yes.
All right. I know sometimes there's other sort of paperwork and tasks you want to get a jump on as far as things go. Were you doing anything else sort of while you were observing her, or how would you describe any other sort of activities that you were doing while in that room?
I wasn't doing anything. I would describe it as staring at her.
Okay. Turning to the intoximeter test, you're aware, part of your training is to sort of know how these machines work and, possible items that can influence or disrupt the tests that they're designed to do.
Correct.
Okay. And, you know, along with any other sort of indicator or any sort of test, there is a margin of error with the intoximeter. Is that correct?
I don't know.
You don't know whether there's a margin of error in the test?
Correct.
Okay. So in terms of this diagnostic test, cycling back to the subject test, which you have in front of you, Exhibit 3, I think it is, for the record.
Exhibit C.
C. All right.
Do you mind if we turn the lights back on? Oh.
Yes, I'm not going to need it.
Okay,
I think we're sufficient as far as that goes.
If you need to turn on the video game, Mr. Habit, just let us know. We'll
Okay.
dim the lights.
So in terms of the diagnostic check that it runs, could you take us through that once more again in terms of what exactly that's measuring?
The diagnostic test is just making sure all the electronics within the instrument are working properly.
Okay, so there's no gas being blown through it or anything like that?
No.
I'm going to turn back to the maintenance test document. Exhibit D, I believe it is, in the file. There is I believe on the third page, there is a document dated July 26 of 2019. At the bottom of, toward the bottom of the page, there is a paragraph. And it indicates, you know, it ends with the sentence, it ends with the clause, it will produce the following results subject to normal instrument variation. Do you see where I'm talking about here?
Yes.
Okay, and it does in fact say that.
Correct.
So there is there can be a variation in the results according to this document.
I'm not trained to testify to this document.
But you would agree that that's what that document indicates, that there is a variation in this instrument?
Objection, foundation.
Sustained. You want to lay the foundation, please?
All right. Cycle back to the search of the vehicle. You had found 2 wine bottles in Miss Kania's car. Is that correct?
Correct.
Did you cite her for having an open intoxicant in the vehicle?
I did not.
And do you have a reason for that?
I used my discretion and I chose not to cite.
Okay. Did you examine the wine bottles yourself? Or was it officer? Were you the one who conducted the search of the vehicle?
Yes.
Okay, because I remember there were 2 of you. I
Yes.
just wanted to be sure. Okay. Could you describe, I mean, were the wine bottles full, empty?
They were empty.
They were empty. Okay. Do you know if they were dry, or if they were completely empty, or if there was a little at the bottom, anything along those lines?
I do not recall.
Okay. So it's possible that Ms. Kania could have drank them at some point during her drive down to Stoughton.
Yes.
Okay. And you wouldn't know when those bottles have been drunk, if they had been drunk by her, or anything along those lines?
That's correct.
Okay. I have, and I'm sorry, you would agree that under the law you are looking to determine the, among other things, no, never mind, I have nothing further.
Okay.
Yeah.
Thank you, Mr. Abbott. Anything on redirect?
Very brief. Officer Johnson, you did not have any input into responding to the records request that we referenced as part of your testimony, correct?
Correct.
And it is your testimony today, under oath, that you are certified to operate the machine, is that correct?
Yes.
Nothing further?
Anything on recross?
No, Your Honor.
Okay, thank you. Officer Johnson, you may step down, thank you. Does the city have any further witnesses?
No, Your Honor.
Okay. Mr. Havich, do you have any witnesses?
No, Your Honor.
Okay. We'll close the evidence then. We'll proceed to closing arguments. Ms. Collins O'Hara.
Thank you. We do have three citations today. I didn't hear any evidence that would refute the speeding violation. The officer testified that he did use radar to as a basis for that citation, so I would ask that the court find Ms. Kania guilty of that citation. For the other two, related to the alcohol content and impairment, to begin, there is a presumption that the .08 is that evidence does create a presumption, that the defendant was under the influence of an intoxicant and that she did in fact have the alcohol concentration of .08 or more. It is the defense's burden to refute that presumption. And for the impairment, we heard a great deal of testimony from the officer of the different clues that he observed, also the other observations he had in his in speaking to the defendant, including the odor of intoxicants, the bloodshot and glassy eyes, the slurring of her words. We also saw the video for ourselves as far as these tests go, including the stumbling to start the walk and turn test, the inability to complete the one leg standing test for her own safety, and also missing quite a few letters as part of the alphabet test. Given all that the officer observed, he was able to reach an opinion that the defendant was not able to safely drive and was too impaired to do so safely. So we ask that the court find the defendant guilty of the impairment citation, and again, with the .08 reading on the intoximeter, find that she is also guilty based on the chemical testing. The officer gave us many different factors that he relied on, many different tests that he relied on. This was not based on one single incident or consideration. We do know that the stop was based on the speeding, which again was confirmed by radar. The contact that the officer had with the defendant gave him good reason to request the testing and then move forward with the probable cause for the arrest. Further, as you can see on the intoximeter report, there was a full hour between the stop at 1:20, and then when the, excuse me, not a full hour, but the stop at 1:20 until the beginning of the test at 2:12, and then the end of the 12th test at 2:20. So not a great deal of time passed between the two of those. And therefore, I ask that the court find the defendant guilty on all 3 citations.
Thank you. Mr. Habich.
Couple items here. As far as the walk and turn test goes, the officer admitted that various conditions and injuries, such as the ones that Ms. Kania described, can influence the outcome of the tests. And Ms. Kania herself described herself as very clumsy and indicated a number of reasons why she may have difficulty with the test. She went through them and performed as best she could as far as that goes. But in terms of alternative explanations, they are plenty in terms of the reasons for these clues, the footwear she was trying to make these tests in, and her, what she describes as her ordinary clumsiness with both the one-legged stand and the walk and turn. And the officer agreed that the factors and the injuries that she had listed could impact the outcome of those tests. Now, as far as the video shows, Ms. Kania was responding to the officer's directives, was in fact asking him sort of clarifying questions on the tests themselves, and was throughout very alert mentally, very responsive as far as that goes, and even at several points understood the tests, understood the complications that she herself had in trying to perform them, and conveyed them to the officer in a clear and concise manner. She indicated the number of drinks that she had had. I mean, granted, there was some back and forth in terms of initial denials and so forth, but again, she mentioned that she had a hibiscus sour and some red wine. I'm not sure how anybody says the word hibiscus sour when they're under the influence without slurring that word, but it came through loud and clear as far as the audio would indicate as far as that goes. And as far as some of the bloodshot, other indicators, the bloodshot glassy eyes, there are alternate explanations for that were present in this case, notably the contacts as far as that goes. And she did note that Polish was her first language, as far as cycling back to the alphabet test as far as that goes, and that, despite her, she does have an advanced degree as far as and expressed her fluency in the English language, and was asked to recite a portion of the alphabet under, let's say, unnatural conditions on the side of the road between 1 and 1:30 a.m., in a language that, while she expresses her fluency in, is not her first language. Again, that test is not one of the primary standardized field sobriety tests that are conducted. The first 3 are. This one was an additional test that the officer himself chose to run. So there's enough. While there is a presumption given the test and the time which it's been conducted, that was the blood alcohol level at the time of the offense. It is a rebuttable presumption and is not a mandatory presumption as far as that goes. And there's a number of indicators, in actually both directions, that would indicate that her BAC could have been lower at the time of the offense. I mentioned the performance on the tests, which would seem to throw that into doubt given the other indicators and explanations present in terms of her conditions, in terms of her own issues with balance, as well as the distinct possibility that the 2 empty wine bottles found in the back were consumed at some point during her drive down to Stoughton. In terms of that, I know there was an expression of, there was definitely some back and forth in terms of her denials and then her eventually coming clean about some drinks, but it is possible that those other bottles of wine were another sort of one that Ms. Kania may have refused to sort of allude to, so as admit to drinking in an effort to shield herself from those troubles. So if she had those bottles of wine, it's a significant amount of alcohol, much closer to the time of the stop, and it is possible scientifically for her blood alcohol level to be on the rise such that it could be below 0.08 and then hit a 0.08 later on at the time the test was conducted over an hour after the stop. So for a myriad of reasons, the city has not proved by clear, satisfactory, and convincing evidence of her intoxication, of the OWI charge, and the PAC charge. Yes, and admittedly, I do have nothing on the speeding as far as that goes. I have nothing further.
Okay. Anything on rebuttal?
Get your book out for opening talk kit. Just kidding. I think we have evidence that we heard on the video of alcohol, the last alcohol being consumed by the defendant at 10:30. That would make it far less likely that at 1:20 she was below 0.08 than when the result came back at 2:20. It just doesn't make sense as far as what she admitted related to her own alcohol usage. The defendant was also born in 1997, so as far as issues with hips, knees, etc., she's a very young woman who should be able to complete the test without any of those types of concerns. And even if you do believe that any of the explanation standing alone may have influenced one of the elements that the officer observed, it was a totality of the circumstances, including all the different things that he observed and the different results of the 3 recognized tests and the alphabet tests that led to his conclusion related to the impairment, and the intoximeter test speaks for itself.
Okay, thank you, Ms. Hannah Collins. Okay, with that, we'll close the arguments. I'll render my decision. First of all, let's talk about the speeding citation. Speeding citation, according to the testimony of Officer Johnson, was 42 and a 25. That's been uncontroverted. There's been no rebuttal. Radar, I have no evidence other than that what the Officer Johnson testified to. So therefore, the court does find defendant, and it's Zuzana Kania, correct?
Yes.
Ms. Kania, guilty of the speeding citation of 17 over in a 25-mile-an-hour zone. When deciding an OWI case, I have to follow through on a progression that would start with reasonable suspicion. Officer Johnson had reasonable suspicion to stop the vehicle based upon the speeding citation. Now, in the closing arguments, I heard some testimony regarding regarding summation of 2 empty wine bottles, and also that the fact that the defendant was born in 1997. I'm going to ignore all the evidence regarding the 2 empty wine bottles. I really don't think that they were, I mean, they were present in the car, but they weren't cited. I'm not going to factor either of those, the age of the defendant or the 2 empty wine bottles, in my decision. After Officer Johnson established reasonable suspicion, he then approached the defendant. Officer Johnson provided a summation of all the things he observed, including an S-type swerve, admission to drinking after some back and forth, odor, bloodshot eyes, slurred speech. He also cited the clues on the field sobriety test. Given that he smelled it and testified that the defendant, Ms. Kania, was the only one in the vehicle, I think that lends credence to the fact that there was alcohol present on her breath. He had the probable cause to investigate further. This court will always encourage, you can't just, like Terry versus Ohio, can't shrug your shoulders and walk away from it. You always have to, it's always best practices, so to speak, to investigate further. Then came the odor, then the bloodshot eyes. Under the totality of the circumstances, given all these speeding, S-type serve, admission of drinking, the odor, the slurred speech, the bloodshot eyes, the 5 clues on the HGN, 5 clues on the walk and turn, and 3 on the one-legged stand, I think there was totality of the circumstances for probable cause for the arrest. Now, Mr. Abich has mentioned that there could have been innocent explanations. I don't really have any other explanations or testimony other than what I heard from Officer Johnson, except for what I saw on the video. This really was an interesting case. It's the first time I've ever had a case where I heard testimony and then saw a video. But from what I could see on the video, it corroborated Mr. Johnson's testimony. Even down, I found Officer Johnson to be credible. I just found that what he corroborated with his evidence. I did see when the defendant did the walk and turn, she didn't take the short, choppy steps as he advised, and she did stumble off the line. It was really illustrative that he wrote an accurate report and testified accurately because what he stated was exactly what I saw on video. And frankly, for me on the video, there was enough indications that the defendant, Ms. Kania, was impaired. So given all this, given all the totality of the circumstances, what I observed in the video, what Officer Johnson testified to, I will find that the city has met their burden by clear, satisfactory, and convincing evidence of the operating while intoxicated citation. Next, after progressing to the police department, we'll find that the 20-minute observation was followed. The documents I have in front of me, the courtroom the accused was correctly read. A defendant did submit to a test. Given all, I am concerned that the open records request did not reflect that Officer Johnson had a updated written copy of his test certification. However, based upon Officer Johnson's testimony that he is certified, I will find that he is certified and then could administer the test. Looking at the test results and the maintenance reports, it is a close call. I've seen much worse than .083, but I will find that given I don't have enough evidence here to consider a curve argument or anything, this test is presumed to be accurate. I will make the finding that it was done within the 3 hours of being stopped. According to the testimony, he pulled her over approximately 1:07 a.m. I have to refer to my notes, but it's around 1 a.m. and the test was given. One at 2:14 and the other at 2:19. That's within the 3 hours. The presumption is that it is accurate. It is above a .08. It is over the legal limit for the state of Wisconsin. Given all this, I will find that the defendant guilty of operating a motor vehicle with a prohibited alcohol concentration and adjudicate her accordingly. So found guilty of the PAC, the speeding, and the OWI. In looking at this, we'll discuss penalties later, but since she's a below a 1.5, I haven't heard any evidence that this was a second. There will obviously be no IID ordered, interlock ignition device ordered for her vehicles. Make sure I've covered everything. The final note regarding the video, I will make the finding that the alphabet test although not a standardized field sobriety test, does give some indications that if somebody was impaired. And from what I could hear in the video, she did skip a few letters. She went from I to L, and it was unclear. And I only heard testimony that she was fluent in English. I didn't know that she was, Polish was her native language, and without any further evidence other than what I could witness on the video, I just can't take the weight of her being fluent in Polish her first language. I just don't have enough evidence there to consider, other than the fact that she did slur her speech. She could not say the alphabet, which added to a contributing factor. Okay, given out. So, and so I will make the finding that the court, or that the city has met their burden in all three cases by clear, satisfactory, and convincing evidence. Now on to the penalty provision of, normally I'll let everybody argue penalties, but given the fact that this is .08, this court's policy is to give the minimums on this. The minimum will be a 6-month driver's license revocation, 6 points. Court will order that she attend an alcohol and drug assessment class. What is the minimum forfeiture?
$735.
Okay. Is that agreeable, Mr. Havich?
If that's the minimum, then yes.
Yeah, I'll give her the minimum forfeiture of $735. I only know it's $150 plus cost plus the $345 assessment. I'll accept the city's version that it is $735.
So that includes the cost of the assessment?
Correct.
Okay.
Okay, so 6 months, no IID, 6 points AODA fine. This was breath, so no cost of a blood draw either, and I'll make some findings. How much time would defendant need to pay? Standard is 30, but for some of these, for OWI cases, the court will extend the time owing.
Let's say 60 days. I don't know if there's a other sort of payment plan option. But let's say 60 days for now, and if we need to, we will let the court know.
Normally what will happen is I give 60 days, and then if they want to ask for more time, they can always call my clerk. And then most of the time, I grant that extension automatically. In the city's past practices, they don't have any objection to that either. Now, Mr. Abbott, you'll review your, as you know, the defendant has 20 days to appeal my ruling, either a de novo hearing or on the record. And you'll advise your client of her appeal rights?
Yes.
Okay, and we'll send you the form as well. Actually, we have that right here if you want to accept that. Okay, apologize for the video, but I think you both did an excellent job in making it work, so we got it to...
Thank you
we'll
for
have to,
dealing with
the upgrades as well.
having the technical difficulties.
All right. We've gone through appeal rights. Anything else from the city?
No, Your Honor.
Anything else from you, Mr. Abbott?
Not really. I mean, some of the issues that you alluded to not being there were present in the video as far as that goes, that block of time, but I understand you.
For the note of record, I will just indicate that it was the exhibit. Once I receive it, I'll keep it, and that the video was only for that 11-minute period and not beyond that. Oh, yes, thank you. The speeding citation, the face amount of the citation was $124, and the court will impose that penalty as well. $124 is in addition to the $735.
Same time frame, Your Honor?
Yes, Your Honor, yes. Anything else?
Nothing else.
Okay, that case is adjourned. Thank you both.
Thank you.
Thank you.
Do you want this down there?
Yeah, if you run into difficulties with that, just let us know and we'll...
Oh, let me go back on the record for just one more minute. Something that I should have mentioned, that there was a motion in order to stay the administrative suspension. That is obviously denied. So, okay, just to make that clear, part of the record as well. Okay, thank you.
Thank you.
Finally did it.
Okay. Oh. Let me go through the rest.
Okay.
Brookfield is the main sort of office, and they handle a lot of the records, sort of. Yeah, so as a mailing address, that's fine, but if you have, you know, if you can send them electronically to my email address, that's perfectly fine as well.
All right, thank you.
Yep.
Let's start defaulting.
If you want to do it like there are only two
Sure.
that really have specific items. This, the OWI, and then the name is, do you have your list?
This one?
Yeah.
Or the other one?
Yeah, the initials. Weren't we gonna just blanket? Okay.
No, I'll go through them.
Okay.
I'll go through them.
If you wanted to, though, there are only two that really have anything.
Okay, but there's one that okay, Andrea Lynn Zerba Allen, default, I'll make a note of the record. I'm Facebook friends with Miss Allen, just for the record, but I'm still defaulting her. There was a recent court case where that should be disclosed, so I want to make sure I disclose Facebook friends. Adam Arndt, default on both. Hector Burgos is a default judgment. Heidi Erickson is a default judgment. Parker Fath is a bond forfeiture. Daniel Fitzgerald is a default judgment. Nelvin Misael Galvez Roberlo is a bond forfeiture. Trevon Halverson Williams is a default judgment. Kuani Harris is a bond forfeiture on both. Okay, what do we need with Ms. Hannah Collins?
Oh, I'm sorry.
Yeah, we have a case to review with her.
Let me just put that one in there so I don't lose that.
Sure. Oh, Miss McCullough stopped by and started yelling at literally the court. So what I told her was that if she provided proof of insurance, the slight citation would likely be dismissed.
Yep, I told her the same thing.
Okay.
Yeah, and I think gave her the 60 days that you would
Right.
talk to her about.
I overstepped my bounds a little bit there,
Well,
but
I'm perfectly fine with that.
I wanted to make sure that, kind of quell a disturbance a little bit, so.
Yeah.
She had given her numerous suspensions. Eisenberg is her attorney. She needed to do an AODA assessment underage.
Did she?
She finally did it.
She completed the assessment.
Yay! Where's that when people, you know, get to the other side of what they're supposed to do?
It took a couple of years. This one he completed AODA.
Oh, good.
So his fine is reduced. This one did not.
Okay. I think I've told you this before, for THC, we do have a $439 fine, but I really want to encourage people to just take an assessment, just so they know what they're facing again. And
Okay.
I thought I might have been, I go back and forth about the penalties, but then one enterprising defendant came in and finished it in about 2 hours. So I'm thinking if he did it then,
Okay.
most people
So
should be
will
able to.
you, if they do the test, will you drop the fine amount?
For
Or dismiss
THC.
it? For THC. Okay.
Normally, for juveniles, I zero it out. They're found guilty, but I zero out no driver's license suspension. And then for adults, if it's 439, I drop it to the minimum 124.
124. Okay, that sounds good.
Okay, back to the.
Oh, is that it?
results. Yeah.
Okay, thank you.
Thank you.
Now, is it, it used to be Collins, but is it Collins
It's
O'Hara
gonna be
now?
Collins O'Hara.
Yeah.
Okay, you're
Yes.
done.
Well, I guess it is. I went to Social Security and everything.
Okay, good.
State Bar is next.
O-H-A-R-A.
And capital H, he would tell you. I guess I'll be worried about that now.
All right.
He was like, good luck, it's so much harder to search your name now, because sometimes it's capitalized, sometimes there's
CCAP,
apostrophe.
hyphenated names are difficult to find in CCAP.
Yeah.
I've noticed that, so.
All right, thank you, I'm ready for dinner. Thank you so
All
much.
right. Thank you.
This is just a lot of information, but the main part is, he or she blew a .15, however, it was previous in 2006 anyways,
So IID has to be ordered on, who's this guy? Hassan Abdurham. Hassan Abdurham, 1-5, so we'll do the 6-month DL revocation. Second first. Yeah, so 6 month, second first. But I will order an IID be installed on all vehicles registered in his name.
6 months or something.
Yep, 6-month DL revocation. Well, actually, what was his? You know what, he didn't come to court tonight, did he? So 7 because, I'll do 7 on IID. Because it's over 1.5. And impose a $50 surcharge. Okay, thank you. Aaron Henderson is a default judgment.
No penalties on that PSC then also?
Yeah. Missy Havlicek is a default judgment on both all three citations. Christian Indumuhe is a default judgment. Bruce Jansen is a default judgment. Robin Kensler is a bond forfeiture. Margot Kleinfeld is a default judgment. Anthony La Verdure is a default judgment. Farron Lloyd is a default judgment on both. Isael Martinez Guevara is a default judgment. Sheila McBurrow is a default judgment. Jasmine McGee is a default judgment. Tyler Marshall is a default judgment. April Lindorf is a default judgment. Ryan Novak is a default judgment. Danny Perkins is a default judgment. Yeah, absolutely.
He has two others that are in the middle of having pre-trials. Actually, it's probably in your folder that she gave me today. I don't know what she decided, if I should automatically add a third one.
No, it's fine.
No.
The problem with disorderly conduct with a motor vehicle, it's a minor
It's the third
offense.
one.
There's a fine increase on that?
Sure.
It's an ordinance violation, though.
That's right, yeah, so I'd have to check the statute.
I'm okay with it without the enhancer.
You know what, can I, while you're doing this, I'll see what she. Oh, yeah.
That's right. Oh, that'll appear. You know what? She'll be calling back. If she calls back and she misses that, we'll probably reopen and get an attorney.
Well, she didn't say she was representing her on this third.
Oh.
That's what I'm
Oh,
saying, do I
yeah.
automatically group them
Well, he'll
together?
do it if you're on with her.
Right, right, for the others.
Well, with an attorney, he'll do
Yeah,
it?
yeah, right.
Yeah, she'll be calling.
And it's just the third, so, and the attorney did not send me anything on the third, so. Okay. Sorry.
It's all right. All right, ready? David Pester is a default judgment on all three. James Radloff is a default judgment on all three. Sheila Rawl is a bond forfeiture. Teron Randall is a default judgment on three.
No,
Okay. William Sachet is a bond forfeiture. Daniel Salk is a bond forfeiture. Serena Segabarth is a default judgment. Carter Smith is a bond forfeiture. Kathy Swanson is a bond forfeiture. Jacob Swenson is a default judgment. Tom Swenson is a bond forfeiture. Let's see. Wade Voss, default. Order restitution of $2, Dollar General. Don Warren, he's the one that entered a not guilty plea. Terrell Washington is a default judgment. Brendan Wiesner is a default judgment on both. Dorothy Wendt is a bond forfeiture. Ekaterina Wick is a bond forfeiture. Tariana Williams is a default judgment on both. And Amy Wren is a default judgment. Took care of pre-trials, took care of those trials, hearings. All right, that concludes court for this evening. Thank you, court's adjourned.